The Father, and the Son, and the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. We salute the flag. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call.
Councilor Donahue. Councilor Elliott.
Here.
Mayor Martin.
Here.
Councilor Armin Mercia.
Here.
Councilor Rita Mercia.
Here.
Councilor Milanazzo.
Here.
Councilor Ramirez.
Here.
Councilor Broderick.
Here.
Councilor Caulfield.
Here.
9 present.
Okay, the first item is approval of the minutes from the March 7th meeting.
So moved.
Moved for approval by Councilor Rita Mercia, seconded by Councilor Broderick. All those in favor say aye. Any
Present.
opposed? The minutes are approved.
Present.
Councilor Mercia has to be recorded as present. Okay, the Chair recognizes Councilor Caulfield.
Thank you very much, Mr. Mayor. Requesting a moment of silence with darkened chambers for Rita Cochran, a loving and devoted wife, mother, grandmother, retired Lowell High School teacher. And for Laurent Larry Brule, loving and devoted husband, father, grandfather, retired Lowell firefighter. Mr. Brule served his country with pride and distinction in the United States Navy during the Second World War.
Councilor Elliott.
Thank you, Mr. Mayor. I also want to add, if we could add a moment of silence for Mrs. Hebert, wife of Al Hebert, Pawtuckaville resident, who passed away this past week also. Thank you.
Councilor Rita Mercia.
Thank you, Mr. Mayor. I'd like to offer a moment of silence and darkened chambers for Galilea Estevez, a first-grade student at the Shaughnessy School who died unexpectedly from viral meningitis. Hermes Pina, a resident of Lowell for 27 years, who was brutally murdered while looking for bottles and cans. This was a gentleman that my family knew, who wouldn't hurt a soul, who kept to himself and tried to make some extra money in a way that only he knew how. I also want to add Rita Hebert as well, who was the wife for 54 years for Al Hebert, the president of God's country. She truly is in God's country now, and I attended a wake just a little while ago for Val Meekish Betancourt, who died unexpectedly at 55 years of age, husband of Livramento, father of one daughter, Melanie, and his 2 sons, Jordan and Ryan. Mr. Betancourt was very active in the Portuguese community. He allowed me to be a guest at his home in Graciosa in the Azores. These Lowell residents will be truly missed. Thank you for letting me say that.
Okay, thank you. May they rest in peace. Under the city manager's portion of the agenda, we have a communication requesting out-of-state travel for the Division of Planning and Development. What's the wish of the council? Motion to approve by Councilor Caulfield, seconded by Councilor Broderick. Roll call.
Councilor Donahue.
Yes.
Councilor Elliott.
Yes.
Mayor Martin.
Yes.
Councilor Armin Mercia.
Yes.
Councilor Rita Mercia.
Yes.
Councilor Milanazzo.
Yes.
Councilor Ramirez.
Yes.
Councilor Broderick.
Yes.
Councilor Caulfield.
Yes.
9 yeas.
The next item is a vote authorizing the Lowell Arena and Civic Stadium Commission and the city manager for and in behalf of the city of Lowell to execute an easement to Massachusetts Electric Company, now known as National Grid, for the installation of an underground electric distribution system. Said system is located in, through, and under, over, across, and upon certain parcels of land situated on the northerly side of Pawtucket Street in said Lowell. Motion to waive the full reading by Councilor Milanazzo, seconded by Councilor Ramirez. All those in favor say aye. Any opposed? That motion is adopted. Second reading by title, a vote authorizing the city authorizing the Lowell Arena and Civic Stadium Commission and the city manager for and on behalf of the city of Lowell to execute an easement to Massachusetts Electric Company, now known as National Grid, for the installation of an underground electric distribution system. Said system is located in, through, under, over, across, and upon certain parcels of land situated on the northerly side of Pawtucket Street in said Lowell. Any questions? Roll call.
Counselor Donahue?
Yes.
Counselor Elliott?
Yes.
Mayor Martin?
Yes.
Counselor Armin Mercia?
Yes.
Counselor Rita Mercia?
Yes.
Counselor Milonazo?
Yes.
Counselor Ramirez?
Yes.
Counselor Broderick?
Yes.
Counselor Caulfield?
Yes.
The next item is an appropriation transfer in City Council in order to meet fixed charges and current expenses for the City of Lowell for the year 2005-2006. Be it ordered by the City of Lowell Council as follows, that the amount of $15,000 is hereby appropriated to health, salaries and wages temporary, $10,000, and health, salaries and wages overtime, $5,000. And in order to provide for such appropriation, the above amount is hereby transferred for said purpose from health, salary and wages permanent, to provide funds for temporary employees to cover positions that are vacant due to family medical leaves. Overtime is needed for upcoming fairs and festivals, as well as the GEO TMS data entry matter. Second reading by title, an appropriation transfer, the amount of $15,000 to health, salaries and wages temporary, $10,000, and health, salaries and wages overtime, $15,000 from health, salaries and wages permanent, $15,000. Any questions?
No.
Roll call.
Counselor Donahue?
Yes.
Counselor Elliott?
Yes.
Mayor Martin?
Yes.
Counselor Armin Mercia?
Yes.
Counselor Rita Mercia?
Yes.
Counselor Milonazo?
Yes.
Counselor Ramirez?
Yes.
Counselor Broderick?
Yes.
Counselor Caulfield?
Yes.
Under subcommittee reports, Councilor Milonazo.
Thank you. Through you, Mr. Mayor, the Economic Development Subcommittee met this evening at 5:30 to review a vote that was referred to the subcommittee at last week's full council meeting. And actually, there were 3 votes authorizing the amendment of an existing economic opportunity area, approving the 9298 Middle Street Economic Opportunity Area, and another vote approving a certified project application and authorizing a tax increment financing agreement for 92 to 98 Middle Street LLC. The city manager and assistant city manager Matt Cloggins presented the proposal, the reason for the 3 votes, and suffice it to say, we have another economic development project in downtown, specifically on Middle Street, that will go a long way in the opinion of the subcommittee, which, by the way, voted unanimously to approve all 3 votes and recommend their approval to the full council to bring about further investment in the downtown area. The gentleman, the LLC, is represented by Mr. Cronin and Mr. Kelleher and Mr. Kaplan, and they purchased the property at 9298 Middle Street. They're actually renovating the property. The total investment will be about $4.5 to $5 million. The first floor will actually house, I believe it's called Village Steakhouse, and actually the first 2 floors, and then the 3rd and 4th floors will be retained as commercial space. And the tax increment financing will actually be a way to encourage this type of commercial development. And in your packet, there's actually a breakdown of the tax savings that the developers will realize as a result of actually going forward with this TIF. And if you use the base year of the base amount, of $344,000, which they'll always actually be paying, and then if you use the market value as the property is improved of $1.4 million, the incremental value will be what will base the tax increment financing agreement on. And then there'll be an exemption percentage based upon each of those 10 years. It ends up saving the developer about $96,000 in taxes over the 10-year period. Again, the subcommittee is recommending that we approve this. Again, based upon the overall investment in the downtown area, we truly believe that commercial development, specifically office development, will really counterbalance, if you will, all of the residential development that we have had in the downtown area. And as I mentioned, it was a unanimous vote to recommend approval. It should be stated that the city's actually done 26 TIFs in the last however many years. I want to say probably 10 or 12 years, and we've created actually 1,147 new jobs, and we've retained 1,517 jobs. So this has been a real good economic development tool that the city has used in order to bring about new development. We haven't actually done a TIF since 2001 because of all of the residential development that's been going on, and I think that based upon the fact that we're able to take such an important building in the downtown and put this type of investment, I think is a good project for the city. So we're recommending that the full council approve the 3 votes before us. Thank you.
Okay. Councilor Donahue.
Thank you, Mr. Mayor. I support this vote. When it first came to the council last week, I guess it was, one of the questions that was raised was, if this is a enterprise that's already bought the building, is already developing the building, why would the city be giving a TIF? But we were told by Mr. Coggins and the manager at the meeting that, in fact, the owner could have well developed half the building as residential. And as we've talked many times, we do want more commercial, more office space in the downtown. And so residential's not eligible for TIF agreements, but more importantly, by granting this TIF, we're ensuring that this property will be developed and retained as commercial space, all 4 floors, not just the first 2. So I certainly support it for that reason. And also, I think it's important to note that this program, the TIF program, and the use here in the city has been very successful, that we've had, a large number of jobs retained over these past 10 years or so, created and retained in the city that we likely would not have done without the TIF. And I think one of the figures that was quite impressive was that with the 25 TIF agreements that we've done over the years, that has generated about $166 million worth of development, and I think that's a pretty significant figure, not just for the city, but for any city. So I certainly support this agreement. The savings to the taxpayer over the course of the 10 years certainly enable. Is there something going on with this system? Certainly enable the developer to put in what are going to be very expensive features to this development, including elevator and the like. So I think it makes sense. It gets a prominent building developed, and we retain it as commercial space for at least the 10 years of the TIF. And so I wholeheartedly support it now that I've gotten the full story.
Okay. Thank you. Councilor Elliott.
Thank you, Mr. Mayor. I just had one question. What happens if this business goes under? What happens to that TIF agreement? Does it remain with the property, or is it with the property owner or the business? And it may be both, but I mean, if the business doesn't sustain itself, does the TIF go away? Is it rescinded?
No, because clearly, first of all, the TIF has to be for commercial use. So if the upper floors were converted to residential, then the TIF would be void. The other thing is, obviously, if it's not successful, then the applicant, the developer, is not meeting his responsibility for job creation, and therefore would be void in that regard. So
would they be responsible for any of the increment? It's sort of an abatement. I don't want to use abatement though, but for the for the real estate taxes that we're sort of forgiving.
If they went out of business, then there would be no assets.
I'm hoping they're not going to,
right,
but I'm just thinking if that happens, then
I don't think there'd be any assets.
The
party wouldn't have any assets to go after, I wouldn't think. But clearly, we're hoping that that's not the case.
Thank you.
Okay. Councilor Broderick? No? All right, so we have a series of 3 votes. The first vote is a vote authorizing the amendment of an existing economic opportunity area Whereas the economic development and job creation are ongoing priorities within the city of Lowell, and whereas Mass General Laws, Chapter 23A, created the Mass Economic Incentive Program, which is intended to promote private investment, create and retain employment opportunities, revitalize distressed areas and communities across the state. Actually, could we have a motion to waive the full reading of this?
So moved.
By Councilor Donahue, seconded by Councilor Elliott. All those in favor say aye. Any opposed? That motion is adopted. Second reading by title, a vote authorizing the amendment of an existing economic opportunity area. Roll call.
Counselor Donahue?
Yes.
Counselor Elliott?
Yes.
Mayor Martin?
Yes.
Counselor Armin Mercia?
Yes.
Counselor Rita Mercia?
Yes.
Counselor Milonazo?
Yes.
Counselor Ramirez?
Yes.
Counselor Broderick?
Yes.
Counselor Caulfield?
Yes.
9 yes.
Okay, a related vote, the next item is a vote approving the 9298 Middle Street Economic Opportunity Area. Motion to waive the full reading by
So
Councilor
moved.
Milonazo, seconded by Councilor Ramirez. All those in favor say aye. Any opposed? That motion's adopted. Second reading by title, a vote approving the 9298 Middle Street Economic Opportunity Area. Roll call.
Counselor Donahue?
Yes.
Counselor Elliott?
Yes.
Mayor Martin?
Yes.
Counselor Armin Mercia?
Yes.
Counselor Rita Mercia?
Yes.
Counselor Milonazo?
Yes.
Counselor Ramirez?
Yes.
Counselor Broderick?
Yes.
Counselor Caulfield?
Yes.
9 yeas.
Okay, and the final vote related to this project is a vote approving a certified project application and authorizing a tax increment financing agreement for 9298 Middle Street LLC. Motion to waive the full reading by Councilor Milonazo, seconded by Councilor Ramirez. All those in favor say aye.
Aye.
Any opposed? That motion is adopted. Second reading by title, a vote approving a certified project application and authorizing a tax increment financing agreement for 9298 Middle Street LLC. Roll call.
Counselor Donahue?
Yes.
Counselor Elliott?
Yes.
Mayor Martin?
Yes.
Counselor Armin Mercia?
Yes.
Counselor Rita Mercia?
Yes.
Counselor Milonazo?
Yes.
Counselor Ramirez?
Yes.
Counselor Broderick?
Yes.
Counselor Caulfield?
Yes.
9 yeas.
Okay, other subcommittee reports? Does that finish your report, Councilor Milonazo? Councilor Broderick.
Thank you, Mr. Mayor. Last evening, we held a zoning subcommittee meeting at 4:30 that was well-attended. Besides the subcommittee and city council members, there was the building inspector, Commissioner Guthrie, zoning board of appeal members, planning board members, and DPD, as well as the manager. We basically did three things. DPD put on a presentation that brought us up to date as far as how we got to where we're at with the zoning and why we did it, based upon the master plan and implementation of the master plan, some of the amendments that we've made since passing the initial amendment, the initial revamping, and then addressed some possibilities or some issues as to what we could further address to tighten up the code. We spent the majority of the time after that discussing in great detail the TMF, Traditional Multifamily Zone, which was recommendation of Mr. Guthrie, that is probably the weakest portion of the zoning code right now. The multi-use districts tend to fall under site plan and special permit review, yet the TMF, which Councilor Caulfield had a problem with on Westford Street, and a couple other projects were mentioned, don't have any review. They basically are by right build-outs. So that we spent significant time on that, and it was left essentially. There was a letter on our desk this evening. There was a motion by Councilor Elliott, I believe, seconded by Councilor Milonazo, to impose a moratorium on the TMF zoning, a temporary moratorium on the TMF zoning. The suggestion from the law department is 6 months. It can be up to 5 years. Hopefully we don't need that. I don't think we'll need 6 months, but 6 months sounds adequate so we can take our time and adequately amend the TMF zoning. It applies only to the TMF zoning district, and so the recommendation was that we adopt that, and if it's approved tonight, my understanding is the law department will come forward with the proper paperwork for next week. The final issue that we were able to address was the issue of the sign that it's been brought up by former Councilor Curtis LeMay. I have to give him a plug on it. It's essentially to be posted 14 days prior to the issuance of a building permit. And Commissioner Guthrie is going to work with DPD in coming up with some standards and also some rules on how it's going to be enforced when the sign goes up, and as importantly, how we're going to get them back so they're not left up by people. That's going to be, we actually recommended, I think Councilman Milazzo made a vote to recommend approving them coming forward with with specifics and a plan, hopefully for next week. We have a meeting next Tuesday at 4:30 to allot ourselves 2 hours because these tend to be lengthy and detailed matters. So anybody that it's open to the public, and it's been well attended so far. And thank the public, the public sector for coming and showing their support and giving their insight. So basically, we decided that we want to go with recommend a moratorium that would be prepared for next week, and we have a DPD and the building department putting together the plan for the sign. Hopefully that will be ready for next week's subcommittee meeting and to be brought forward for a vote next week. And lastly, the Planning and Development Department did a fantastic presentation for us, and Councilor Elliott thought it would be a good idea to bring it forward to the full council, because we all get the same complaints, and it would be a way to put things in perspective so that we all realize that we're only getting the complaints. We're not seeing the positive things that the zoning amendments did do from the last change. For instance, Westford Street could have been 7 units rather than 2. That doesn't mean that 2 is sufficient in a good plan, but it's much better than 7. So Councilor Elliott made the motion, Councilman Milazzo seconded, to have DPD come in. We thought next week to put together, to show the rest of the full council a short 5 or 10 minute presentation on some of the changes and the effect it's had, and so that everybody can be brought up to speed as to what's going on. Thank you, Mr. Mayor.
Okay, thank you. Councilor Ramirez?
Yes, thank you, Mr. Mayor. Through you to the city solicitor, I was just wondering if you could, what kind of an effect would this moratorium have on existing projects? Or would this only apply to new projects that are just starting?
What we would hope to do, Counselor, is to create a freeze period whereby any questionable projects will not go forward once this thing is advertised, so that it will give the council and the planning department enough time to fix whatever needs to be remedied and then move forward. As far as the 6-month period, as Councilor Broderick had mentioned, it most likely won't even take 6 months to make these kinds of changes, but it was a 6-month recommendation for the specific reason that we will give ourselves plenty of time, and you can revoke it at any time.
But the current ongoing projects wouldn't be affected, or they would be affected?
If a project has already been approved, it would not be affected. Okay. Secondly, if there had been something submitted to the building department, and as the result of this zoning change, it would completely prohibit the project from going forward, that would then be grandfathered in.
It would be,
all
okay.
Other projects would fall under the new zoning amendments.
Thank you. I was concerned about those projects that may be awaiting the building inspector's approval. I'd hate to have a chilling effect on the economy and building and lending. It's just more than the builder, it's the bank, and it's a host of folks. But no, that answers it fine. Thank you very much.
Councilor Elliott?
Thank you, Mr. Mayor. I think the chairman really recapped a lot of the issues, and we still have a lot of issues that, as he mentioned, we're going to meet again next week for 2 hours just to continue to work on these. And I think the 2 motions that he brought forward tonight, one on posting, erecting a sign on every development that's taking place, whether it's a 2-family or a zoning change, a special permit, or a building permit, really is going to go a long way to letting people know in the neighborhoods or the homes that they live next to what is taking place before it's too late. I think it's a good way to open up the process even more, because it's been made very clear to me and I think all of us sitting here that what is taking place is not what would they'd like to see done. So I think that's the first step. And secondly, I don't think we don't want to stop progress in some of the other zoning areas, but again, I think it's been clear that the TMF zones, we need to make some additional corrections or modifications, if you will, because there's still too many units that can be put in these zones, and Westwood Street was just one example of what can take place. So rather than let more projects like this ruin neighborhoods, if you will, the zoning subcommittee thought that we should just, put a freeze on, as the solicitor mentioned, and correct what needs to be fixed, and then proceed. And I know we're looking at 6 months. I don't think we envision a 6-month time frame. Last night we talked about, we spoke of 30 days, but just, we can remove that as soon as these zoning changes or amendments are in place. By the time we meet again, and it has to be advertised for, is it 2 weeks, Madam Solicitor? So it has to be advertised for a couple of weeks, and there's still a lot of work that needs to be done in some of the other areas too. But for the immediate future, we don't want to get any more concerns, complaints on developments that are taking place that we didn't intend to be approved. So I just had one more clarification. I don't know if, and this is from the zoning subcommittee last night, either you, Madam Solicitor, or Mr. Coggins, but do any development projects in the TMF zone require site plan and a special permit, or is it special permit up to 4 units and 7 units above requires a special permit? Excuse me, site plan review and then special permit. Is anybody here?
Right.
It's you.
By default. I believe that's correct. That anything beyond, that if you were to have a 7-unit, it would require both special permit as well as site plan review.
Okay.
But I can take a look and double check on that. I just don't, I don't know it offhand.
Okay. We should also note that, the neighborhood organizations were also there, and Amory Page and, other residents that are continuing to provide input on how we can improve the zoning code. So, thank you, Mr. Mayor.
All right. I think Councilor Broderick may know the answer to that question.
Yeah, I believe it's 4 units. Anything over 4 units or more requires site plan review. But in the case of these smaller subdivisions, where it's 2 units, those are the ones that are just slipped right in, and there's no review.
And is it 7 units require site plan and special permit, or just site plan?
Right, the special permit is triggered by something different. The number of units that triggers the site plan. The special permit would deal, I believe, with use. That's usually what we're talking about, sending back to ZBA.
Thank you.
Okay. Councilor Caulfield.
Thank you very much, Mr. Mayor. First of all, I want to compliment the chairman of the zoning subcommittee, Councilor Broderick, Councilor Elliott, Councilor Milanazzo, DPD, and everyone who was in attendance at the meeting last evening. It was a well-discussed and sometimes heavily debated issue, but I think it's a very important issue for this city, especially in the Highlands, sections of Belvedere, Centerville, Pawtuckaville, so forth. The traditional multifamily units, after what we've seen, what happened on Westford Street, this can continue to happen in the Highlands and throughout the city if we do not address it. And I think the moratorium, a 6-month moratorium, is needed, it's appropriate. It gives the subcommittee ample time to go through the process, to go through the zoning amendments and so forth, and bring back to the council something that's going to be cast in stone, that the residents and the constituents that we represent will be happy with. The construction on Westford Street, if we do not amend the zoning, I just feel it's going to escalate, in particular in the Highlands, sections of the Highlands, and I don't think any of us want to see that happen. So I would urge my colleagues to support this moratorium and let the zoning subcommittee do their work with the building commissioner and the DPD and come back with something for the full council to support and adopt. Thank you.
Okay, thank you. Councilor Rita Mercier.
Thank you, Mr. Mayor. So it seems that the next order of business in regards to this moratorium in a TMF district would be to refer this to the law department for the solicitor to draw up the proper zoning amendment for the next council meeting, and then I guess to set a public hearing. So I would move approval on that.
All right.
Second.
I think it's it's sufficient to adopt the recommendation of the subcommittee. But Councilor Donahue?
Thank you. So then it gets sent to, it'll come in with a ordinance, it gets sent to a public hearing,
Right.
and then we advertise it and so forth. I guess one of the questions I have is what, I guess nothing you can do about it, but will there be a stampede for people to go and grab building permits knowing that a moratorium may be in the offing? I mean, there's nothing we can do, right, about that?
Right, once it gets advertised, that will freeze everything,
Yeah.
which will be, hopefully, a
Thursday.
fairly quick
Yeah.
turnaround from
Yeah,
next Tuesday.
okay.
And
would-
when you consider the lead time it would take to actually get building plans in place, I think you're probably ahead of the ball.
How about the putting a sign, what's been recommended? Is that same process as far as public hearing? Does that require a public hearing?
Actually, I'm not sure if the sign would actually trigger a public hearing. I can take a look at that at the
So it
same
might be
time.
nice to, if it doesn't, that the sign could go up if people are getting building permits in the interim before the moratorium, then people could know about it. I don't know. If
Right.
Somehow we could be aware of that.
Sure, I can take a look at that and
Okay.
answer that hopefully at the same time in the packet for Friday.
Thank you.
Councilor Broderick?
Yes, through you, Mr. Mayor. I believe that was somewhat addressed last night by Mr. Guthrie, who mentioned that building permits don't have to be, he has 30 days to review them, so that if this is moved upon timely, the permits may not be issued before we have the public hearing notice, which hopefully would be voted on and put in for next week, I assume. So I think that there may be a way to prevent the stampede from hitting the time
Councilor
clock.
Elliott?
And along the same lines, I thought the building commissioner last night indicated that the erection of a sign or construction of a sign, that didn't have to go through the ordinance. We could make it part of the application process where they fill it out, and that's one of the requirements that the builder or developer has to comply with.
Right, again, I believe it would be more of just an internal rule and
Right.
regulation rather than something triggering a public hearing, but you can certainly take a look at it and make sure that
Because if that's the
correct.
case, the subcommittee did adopt that recommendation to bring forward, that we move on that immediately.
Okay.
Councilor Armin Mercier?
Thank you, Mr. Mayor. Just so I can understand this, if the subcommittee meets expeditiously, makes the recommendation to the council advertises for a public hearing, and a public hearing is held, and the gets adopted, would it be safe to say that if that is done in less time than 6 months, that the moratorium would then be lifted?
Right, what we would do is at
Would be lifted.
the same time that the new zoning regulations would be coming forward,
Okay.
most likely on the same evening,
Okay.
we would the council could adopt the new zoning regulations, and at the same time, in a later vote to revoke
That would
or
lift
lift the moratorium.
The other question I had is, and I wasn't able to attend the subcommittee, but was there any discussion about the sign as it relates to maybe having it printed in a couple of different languages?
I don't believe that came up, actually.
Usually when the government puts something out, they need to include different languages so that everyone in the neighborhood would understand what they're reading. So I was just wondering if that was taken in consideration at all.
We might be able to satisfy that requirement by having a series of messages
Yeah, I would
in
hate
various
to
language indicating that this is an important message,
Yeah.
and you should get it translated.
Okay.
As
Because
opposed,
I would hate to see a situation where someone says, well, listen, it was written in English and I can't read English. And therefore, they would have a legitimate concern about that sign. So I think we ought to look into the need of that sign covering all the languages that we're appealing to in these various neighborhoods.
Yep, good point.
Okay, motion to adopt the recommendation of the subcommittee, which would include refer to the Law Department by Councilor Rita Mercier, seconded by Councilor Caulfield. All those in favor say aye. Any opposed? The report and recommendation of the subcommittee is adopted. Other subcommittee reports, Councilor Donahue.
Thank you, Mr. Mayor. I have two. We had a meeting last night and tonight. The first has to do with the school building subcommittee. We met last night on the Stocklosa School report in subcommittee. This is a follow-up meeting. As the council is aware, this council has been meeting on this, as did the prior council in the last term on this. And the meeting last night dealt with the motions that were made on February 7, 2006, recommendations from the subcommittee that adopted by the council as a whole. The first motion, and we dealt with 2 or 3 of those 4 motions, but just for my colleagues' information, the first motion that we dealt with last night was requesting the manager report on the status of the punch list at the school, including what is remaining to be done, the cost associated, and a report from the law department on what change orders are being held up. We received in our packet on Saturday or Friday, when we got the packet, a report on those change orders. Everybody should have gotten that report. But let me try and summarize where we stand in terms of the punch list. Punch list being things left to be done and completed at the Stocklosa School. The report we were given, which was an itemization of all of the items that remain to be done, total somewhere in the vicinity of about $150,000 of work still to be done. Those listed items include things like the basketball court, that ceiling and painting has to be done, weather permitting. It includes a number of small ticket items, and it also includes some money in terms of the HVAC and control system, the 2 systems that remain a situation that continues to need monitoring and work. The list was somewhat exhaustive that we were provided. We were also told by the manager, by the law department who's been working on this, Ann J. Lang from the school committee, that at the present time there's nothing major outstanding over there, that there are these items that have to be done. One of the issues that makes it a little less straightforward in terms of dealing is that the bonding company for Jackson is now handling, and maybe correct me if I'm wrong, Madam Solicitor, is now handling these issues and items. And so it's not as direct as dealing with Jackson or their subs saying, when are you going to get back in here and do this work, but rather going through the bonding company, and it may or may not be the contractor, it may be another contractor who's doing some of these issues. Is that, Madam Solicitor, is that?
Yes, actually, today I was contacted by a contractor for the bonding company who confirmed that they are going to be doing this work, and we're looking to set up a meeting with the city. So we're hoping to do that next week. Meanwhile, the punch list is being forwarded to them, as well as a number of the outstanding issues that had been sent to council for Jackson Construction. The individual that I spoke to is not directly from the bonding company, but again is merely their contractor. So he indicated that it may well be that that information has been forwarded to the bonding company. He also confirmed that they do have an issue that you'll probably get to in a bit. They also do have all of Jackson's records on this project and will work with us in getting that information. And so what we're hoping is that for next Thursday, potentially, we will have a comprehensive meeting on all of these outstanding issues and a game plan for ultimately resolving them.
Okay.
Including issues of liquidated damages and delay and all those sorts of things.
All right. So currently the city's holding about $1.1 million in retainage, against which there's some $300,000 that are encumbered. So that leaving in the vicinity of $800,000 that the city's holding of monies to accomplish this, the punch list items, as well as if there are other issues that arise. So But we were told that none of these items are major at the present time, with the exception of the HVAC and control system that is under a warranty that the school is aware of and feels that they'll be able to work with. And it may not be something that is fixed the first season. It's something that's going to have to take some time to work with both the heating and the air conditioning. Jay Lang did indicate that this is the first school that is completely air conditioned, and the other schools that we've done in part have been, but not a size of this nature. So that is, though there have been complaints from teachers and the like, I know at the school, it is being worked on, it is being monitored, but that there's no, at least as we know today, major flaw, but rather a question of balancing the systems in depending on the seasons permitting. Was there something else, Ms. O'Connor?
I'm sorry. I was just going to add also, the contractor had indicated that I think he has already been in touch with both contractors for that heating system, and so that's good news in the sense that, you know, hopefully getting both of them on site should iron out any of those wrinkles that are remaining. And
that's been, you know, obviously it's a major expense and a major concern, and the school department wants to make certain, as we do, obviously, that is working up to par. So you know, whether there was a mention last night that some of the subcontractors on the job were stopped getting paid, and therefore they stopped doing work. But presumably with the bonding company handling the matter and a different contractor handling the matter, that these issues will indeed be addressed. And so the matter of subs not getting paid or walking off the job hopefully will be addressed in these items, albeit, you know, it doesn't sound like little items, but on the overall scheme of things, when you're looking at a school of this price tag, if you're dealing with $150,000 worth of punch list items, it's fair to say that we're down toward the end of the punch list in terms of severity of those issues. There was part of that motion also asked for the law department to report on which or what change orders are being held up, if any. We were told that the only outstanding change order, and change order being changes in the contract from the original contract, had to do with the landscaping done at the school. My colleagues may recall that last fall, in an effort to push to get the school open in a timely fashion, it didn't open until October, but there was a need to have some of the landscaping done, actually I believe all of the landscaping done, and the city took the responsibility to get that done, and the contractor was to give a credit to the city because the city took it upon itself to do it, to do the work. We were told that as far as that change order, we're near agreement in terms of a price. And so and again, on this, for those who weren't there, the contractor, Jackson, is saying, you know, the credit should be $110,000 for the work that was done. The city's saying $114,000. So you can see that the difference is not major, and so in all likelihood there'll be some resolution to that, and that's the only outstanding change order as far as the project. So that took care of the first motion. I don't know if my colleagues had anything else to add on that first motion, but let me just continue with the second motion. And as I indicated, there were 4 that were passed on the February 7th meeting. The second one was a request for further information from the law department on the $290,000 payment to Jackson Construction, and asked that the law department provide the subcommittee with a copy of the settlement documents with Jackson, as well as the status of the city's claim for delay by Jackson Construction. Delay meaning delay as far as the opening of the school. This was a more lengthy discussion in terms of the subcommittee. And just by way of background information, this is a matter that was discussed obviously before last night. It isn't a new topic in terms of the 3 classrooms. The $290,000 payment was made to Jackson Construction to settle the dispute, as it were, of the 3 classrooms that were at some point, as alleged, deleted from the plans and then put back into the plans in terms of the school. And so the city, in May of 2005, settled by paying to Jackson Construction $290,000 for adding those classrooms back in. The subcommittee back in February and maybe before, I'm not certain, had asked for information on that. This, the discussion, and I'm trying to summarize this rather than go back in detail because we were there for quite a while last night, and I'm not going to try and, I'm going to try as best I can to summarize it, and I'm sure I'll be corrected if anybody who was present wants to say there was something missed in my summary. But the discussion, there was some discussion on whether or not the 3 classrooms were ever legally deleted, and quite frankly, there's no way of a subcommittee to determining that fact. It's a complicated issue. This whole school, this whole project has been a complex and difficult project, quite frankly, from the get-go, in terms of acquisition of the land, clearing the site, and that's another motion that we actually didn't even get to last night. But the issue of the 3 classrooms, whether the city okayed taking them out, whether Jackson was within its rights to not order things and so forth, and whether or not that caused damage to Jackson, was a discussion that we just left to the side last night because there's really no way of us coming to any firm conclusion in a subcommittee, or that seemed to be the census there. The focus, rather, was on the $290,000 payment made to Jackson. The bid and the monies that Jackson was paid was based on including, when they first bid on this, again, before we got into this project, when they first bid on the school, it included those 3 classrooms. That money was never deducted, and then Jackson claimed because of, be it the city, the architect, or whomever, changing their minds, they were damaged and they had extra costs. This matter had been discussed at length in subcommittees before, in last term as well. And we asked for the information as what we paid them for, as best I can put it. We paid them $290,000. What did we pay them for? Because there have been reports and information that the subcontractors who worked on this job weren't paid any extra for putting these 3 classrooms in. That I think some were quoted in the paper as saying that they had been told by Jackson that this was part of their original contract, they weren't going to get paid. So the subcommittee is saying, look, where's the information as to why we paid them this money? Now, what we're told is that the city reached a settlement in May of 2005, paid the money, and that Jackson was to produce to the city proof in terms of what their costs were. At that point, Jackson claimed not to be in a position to produce that information, but that Jackson would. I think it's fair to say that Jackson still has not provided that information to the city. Rather, Jackson has indicated more recently to the law department that they have, or their attorney has forwarded this information to the bond company, and that they would provide it to us at some point, and that the law department is certainly making requests for that information. The settlement documents that we were provided had to do with the settlement with Jackson in terms of the $290,000 payment, and there was discussion around whether or not that settlement document protected the city, in the sense that if Jackson fails to produce sufficient and acceptable proof of their damages, whether or not the city can recoup the monies. And there was extensive discussion about that fact at the subcommittee. There were two motions made, and I'll deal with one first, and that was because this was a complex project, because timelines can be important by way of background information. Request was made, and I'm not positive it was actually made into a motion, but Councilor Broderick, who was in attendance, had made a request that the law department provide the council with a timeline of this project in terms of what happened when, and so forth, including as best we can, the construction schedule, and so that was a motion that was made. In addition, there was a motion made, and this goes to motion number 4, requesting that Mr. Ed Souza, who was the project manager on this school, be present to answer questions. This motion was made on February 7th, 2006 as well. Mr. Souza has indicated that he would attend a city council meeting voluntarily. We asked for information, and this goes to both. Mr. Souza was asked to come to the council meeting, and there was a request last night that the architect be asked to come to the next meeting, I believe subcommittee meeting, DRA. We asked for an opinion from the law department as to what happens if someone doesn't want to come or won't come voluntarily, and we were told that under Mass General Laws, Chapter 233, Section 8, the city council does have the authority to ask witnesses to be summoned to come and produce information or answer questions and so forth. And so this is complicated a little bit further, however, because there is ongoing litigation in this case. Litigation is pending with the architect, DRA, and they are represented by counsel, I believe. And Mr. Souza, I don't know if there is litigation pending, but the law department did indicate that he may have retained counsel. And so the requests for both of those parties to be, and I don't know, I'm not going to prejudge, maybe they would come, but it adds another layer of complexity, as it were, to discuss some of these issues. So I think in terms of this issue, the $290,000 issue motion, the motion and request for a timeline, I would make that by way of a motion from the subcommittee that the law department provide the subcommittee and the council as a whole with the timeline of this project as best it can be put together. It would seem to me, even though at the subcommittee there was a motion to notify both Mr. Souza and DRA to be present at the next city council meeting, it would seem to me that it would make sense for the council to have the timeline first, so before, and I open it up to, I know Councilor Elliott made the motion about having having these individuals to the next city council meeting. But those were the motions made on that as a result of that particular discussion. There was another motion, and that was requesting information regarding the site preparation. We didn't even get to that issue, but we will at the next subcommittee. And then the last issue had to do with Mr. Souza, having him present to answer questions. You know, again, some of the questions that were raised, it appears that the $290,000 payment he may or may not have information on that. There was questions raised as to when construction was done, who you know, when things were ordered. These are questions that perhaps should be addressed to Mr. Souza if the council believes it's pertinent to the inquiry. So those were the motions. This is a report of progress. This is a subcommittee that continues to have seek information and to deal with this issue. So I make those motions and recommendations from the subcommittee, and I'll yield the floor to if anybody else on the committee who may want to speak to these issues.
Okay. Councilor Caulfield?
Thank you very much, Mr. Mayor. At last night's subcommittee meeting, it was with the intent of having Mr. Souza present, but also either Superintendent of Schools, Carla Brooks-Bear, or George Sapasaris. I believe he was a consultant on the school. And Jay Lang represented the Superintendent of Schools, but Jay Lang didn't know didn't have the minutes or didn't know what happened at meetings that they discussed value engineering. So, Madam Chairman, I'd also like to see either Judge Sapasaris, Superintendent of Schools, Carla Brooks-Bear, attend as well to answer some questions. Thank you.
Okay, do we want to, is the motion for the timeline, is there any debate about that? Should we, so that motion was made by Councilor Donahue, seconded by Councilor Elliott. All in favor of that motion, say aye. Any opposed? That motion's adopted. Councilor Elliott.
Thank you, Mr. Mayor. I just wanted to just say a few words. Councilor Donahue really, excuse me, recap the meeting. It was a lengthy meeting, but we're trying to get to the bottom of, you know, what took place. It's been a long project, complicated project, but we still have an obligation to make sure that we paid for what we paid for, and I think that's what we're trying to do. But people should know that we still have leverage. We still have over $800,000 in retainage. We are pursuing litigation against Jackson Construction. There are still performance bonds that the city hold that we can, you know, pursue. I did just have one question, and I'm sorry, time ran out last night. Are we still holding a change order? We discussed the change order, the last change order, or excuse me, request for payment. Are we still holding that, Mr. Auditor or Madam Solicitor? There was discussion about negotiating what was paid for by the city and done by the city, and credits issued as it relates to landscaping and some other things. So at the prior meeting, there was one more payment outstanding. Have we issued that, or are we still holding that as well?
I believe we're still holding it because I don't have any invoices downstairs whatsoever.
So there's no more invoices, and
No.
so...
They should be holding them upstairs in the law office.
Okay. Okay, thank you.
Thanks. Councilor Milanazzo.
Thank you, Mr. Mayor. Councilor Donahue did a very good job in recapping the meeting last evening. I just had two questions, one for Madam Solicitor. It was reported at the Economic Development Subcommittee, and I don't have any evidence of this, but it was reported at the Economic Development Subcommittee that one of the subcontractors has in fact filed a claim, I believe, against Jackson with the Attorney General's office. Have we been notified of that?
I don't believe that there's any claims arising out of issues in terms of the construction and non-payment. There might have been a claim filed regarding wage rates and things of that nature, and I think the AG's office was investigating it. I can take a look at that and give you a report, but
Okay.
it seems to me I do recall having seen something
Okay.
to that effect, yeah.
Thank you. And my second question to the auditor, when the $290,000 request came to your office for payment,
Correct.
what paperwork was attached to that? Is that the crux of the issue, or usually, when you're asked to, to pay a bill, there's something
Well,
that's
when it
attached
first
to
came
that?
down, I had to call the law office to find out what it was. And I wanted to make sure it was signed off, that it was legitimate, so that it would be paid by our office. So we have the documents as far as coming back from the law office that it was a litigation and stuff like that. And that's how we get paid.
Okay. Yes, Madam
Add on to
Solicitor.
that, it's the exact same process that we follow with any other payment to the auditor's office. What would be required is the actual copy of a settlement document, and that's what's always forwarded to the auditor's office, and that's what occurred in this case
Okay.
as well. Yeah.
Thank you.
Okay. Counselor Armin Mercier?
Thank you, Mr. Mayor. To say that this is a complex project is an understatement, because whenever a project like this, in this nature, with biddings and subcontractors, it is very complex all the way along the line. You have change orders, you have field orders, you make decisions on site with all intention of being the right decision, and ultimately all gets shaked out at the end. On that $290,000 settlement, that was not negotiated only between the city. People negotiating this wasn't only the city and the contractor. Am I right? Was there a third-party influence here?
That's correct. It was part of because Jackson had been footing the entire monetary coverage of this era that took place. There was an agreement between all the parties that all the parties would engage in expedited mediation prior to the completion of the project, which would have in most cases it would have taken place after the project was complete, but because of the amount of the money that was involved, as well as the various issues, it was agreed that that's how we would do it. So there was a session at a JAMS mediation session in Boston. It was a retired judge that mediated it, and it resulted in a partial settlement with one party and no settlement with the other party.
So there was some mediation that came about with this result. I mean, this was
That's exactly what this arose
was
out of.
not just a contractor saying, I want 290, and the city said, okay, I'll give it to you.
No, not at all.
This was something that was mediated at a court level.
No.
Correct.
Okay.
Well, not at a court level. It's mediated at the level of mediation. It's a professional
Okay.
mediation group, and that's what they do.
Did the person in charge, the mediator, let's say, was he on board with this final settlement?
I can't get into, unfortunately, mediation discussions. I can fully inform the council, and I might have before in executive session, but I'd be happy to go in, if there's a desire to go into executive session, to find out what went on in the mediation session. That can be done.
Well, I don't want to get into what went on in mediation session if it can't be done publicly, but when the end result is a check is cut, I would assume the check was cut in agreement by all parties, including the mediator.
The mediator doesn't technically agree to things. It's safe to say that this clearly, unequivocally, arose out of and resulted from and in accordance with a mediation session.
Mediation, okay. I just wanted to clear the record that this was not just two people or two entities negotiating this out, that there was a third party involved here, which was agreed on by both the city and the contractor. Right.
There were
That
actually
seems to
four
be
parties.
escaped here. When
There were
we
four
read
parties.
the sanitized version in a newspaper, that doesn't seem to come forward. So I just wanted the record to show that this was not just two entities negotiating, this included mediation, which was agreed on by both sides.
Right. Again, there was a mediator, and there were three parties involved in the negotiation session: the City of Lowell, DRA, and Jackson Construction.
Okay. The only other question I have is that we just approved the motion, which I totally agree on, to get a timeline. Now, I would like to have the motions that we're going to be considering kind of spelled out. What is it we're asked to approve? One at a time.
Okay.
What is going to be before us right now if the questions have all been
I
asked?
think we're still
I'm sorry,
asking
okay,
and answering
yeah.
questions here.
Okay.
Councilor Ramirez and Councilor Donahue.
Thank you, Mr. Mayor. I just had a question following up to the auditor, because I missed the end of that last answer. Can we get a copy, or can you, again, specify and give us a copy of the paperwork that you received from the law department?
Yep.
In order to pay that $290? Because if you have that, then I think it would obviate Councilor Donahue's concerns and most of our concerns, so.
You have it. Again, to trigger a payment from the auditor's office, from the law department, we would provide them with the settlement documents, and those are also provided to the council.
I'm sorry, City Solicitor. What I received was just a release.
That release was those are the settlement documents.
That was it? So based on those settlement documents,
That's what we send out all the time. We send out, once the parties have a written agreement, that written agreement is then forwarded to the auditor's office to be processed for payment.
but that release doesn't really say anything. It just kind of says it releases each party from rights they may have, but it doesn't talk about what the actual damages were or why the basis for the settlement was.
Well, it's speaking in general terms, you are not necessarily going to have an agreed upon, as part of mediation, one party may argue that the numbers are X, Y, and Z, another party is going to argue that they're A, B, C, but as the result of mediation or some other form of arbitration, there's an agreed upon number, and that's usually hammered out by a mediator. And then once the parties reach that point, and again, I'm speaking as a typical case of mediation without getting into the specifics of what happened in this particular case, then there's an agreement executed. Sometimes it's executed right at the mediation session. Sometimes mediators will follow up with phone calls to other parties and to confirm that there is a deal. And then once that occurs, the deal is finalized in writing, and that's what occurred here.
And I appreciate the process, and I'm familiar with it to some degree. I guess what I'm wondering is, what were the paperwork that each side had going in? What was the debate about? What were the contentions that we settled?
Well, again, we still have ongoing litigation, but I can tell you that, and what was provided to the council, was that it was the position of Jackson that what it was going to cost them at the late date that these classrooms were going in was approximately $365,000, I believe. And that was done with a line item spreadsheet indicating what the costs were, which was then sent to the architect as well. And from that was for the case of Jackson, that was basically what was being looked at by the mediator, by the city, and to some degree by DRA in a mediation session. Those are the numbers that Jackson was presenting. What we're going to be getting, and what we will be getting, I believe, after having spoken to the contractor for the bonding company, is again the backup documentation, because part of our settlement included going after DRA not just for any damages incurred by the city, but also beyond that, out-of-pocket expenditures that were suffered by the contractor as the result of this, that were not necessarily made whole by any payment by the city, that go above and beyond, for example, the $290.
Okay, great, and I appreciate receiving those. One last question, if you could, as somebody that's only been around 8 weeks.
Yep.
Does the law department or the manager have the authority to enter into these types of agreement and pay those kinds of monies out without our approval?
Yes.
Okay, thank you.
Councilor Donahue?
Thank you. first of all, to suggest that the mediation was of a court level is not true. And this was non-binding voluntary mediation. All it means is someone sits there and tries to help you settle the case. That's all it means. And to suggest otherwise is misleading. And number one.
I didn't suggest anything.
Okay,
Otherwise,
well, I'm
in
just
fact, I
trying to
specifically
clarify.
said
I'm trying to clarify
that-
the record
and
because
I specifically said that it wasn't in a court session, that it was
Point
done
of
by a
order,
mediator.
you know, I
Wait,
made
wait.
that assumption. Point of order, Mrs.
no, that's not point of order.
I made that assumption, yes, because you're talking about what I asked for, and she corrected me.
Mr. Mayor,
So,
I have the
I
floor.
just
Okay, Councilor Mercier.
I have the floor. So
Councilor Donahue.
Only if you're accurate, you have the floor.
No. Mr. Mayor, I'm
You'll have your
asking
turn.
for a ruling
Okay.
because every council has a right to speak. If you want to speak after, go ahead.
I just want to
But
make corrections.
But I am going to take issue with being interrupted. I didn't interrupt Councilor Mercier. I don't appreciate being interrupted. You may disagree with what I have to say, but I did not interrupt you, and I would ask that the rules of this chamber be enforced.
That's
Now
why I
that's-
raised a point
Councilor
of order.
Mercier.
Mr. Mayor?
That's only why I raised a point of order.
Councilor
That's
Mercier,
permissible.
you're out of order
That's
now.
not order. That's not point of order. So, and you know, the fact is that, just by way of background, the subcommittee was sitting on this issue all during 2005. We were told repeatedly that we had reserved our rights against all parties, that we were proceeding. Now, at some point, the administration decided to go to mediation. We were not told that. We were not told that at all. This is one reason why we're having the discussion now, quite frankly. And we were not told that a $290,000 payment had been made, nor were we told after it was made. We were only told it when we were at a meeting at the Stocklosa School when the school opened, and the auditor was the one who said there was a $290,000 payment made in response to a question by Councilor Elliott as to what we had in retainage and what had been paid out. And it was only then that the auditor told us what the story was, and in his words, as I recall them, was, should I tell them about that? Now, that's one of the problems that we have here. Now, that said, we sit here today, we still don't know what we paid $290,000 for. Doesn't matter whether an arbitrator, a mediator, a judge, we don't know what we paid $290,000 for because Jackson has not given us that information. That's why we're having the discussion. That's what we're looking for. We paid them on May 27th, 2005. And by the way, Mr. Auditor, when you say you had the information, you at no time knew when you made that payment what you were paying that money for, other than you were told by the law department to pay it, right?
Mr. Auditor.
When that came down as an invoice, I had called up the law office asking what it was, and it was in litigation, and it had come down in the proper way, the blue voucher attached to it with the backup to be paid, and signed off by the law office. And that's how it was paid. And not only didn't say that, can I tell you this at that meeting, that I can give you this $290,000 on that report that I gave you. I did not say that, so I would back up and say what you think you're saying.
Oh, really? Well, that's my recollection, Mr. Auditor. At any rate, that was the first time we were told about a $290,000 payment. That was the first time. Now, that's why, one of the reasons why we've been asking for this information since that point of time. All right, what did we pay $290,000 for? What did we pay it for? That's what we're asking. Now, I accept the fact that you don't have that information from Jackson. I accept that, and that you're still waiting for it. The only issue is when you say, oh, it was a settlement and this is what it was for, all that Jackson provided was a spreadsheet. They could put any number on that spreadsheet that they wanted to. And that's why we're inquiring. Now, there's nothing improper, micromanaging, or anything like that to be looking at why Jackson was paid $290,000 when not only had they been paid for the 3 classrooms once, and then if they had damages, then prove it. Where they were months behind in getting the school open, these are all the issues. I think everybody wants to get to the bottom of it, see what happened, and move on. You know, that's where we're coming from. But, you know, the notion that this was somehow, we have all the answers. We don't have the answers. We don't have the answers. And that's why we continue to work on this issue. It's as simple as that.
If I may, Mr. Mayor?
Well, Councilor Mercier, do you want?
I'm all set. I just wanted to clarify my position, and I have.
All right, Mr. Manager.
Thank you. Good evening, councilors, ladies and gentlemen. I was trying to stay out of this, and I almost did, and I hope it, I don't want to prolong it. We had a 2-hour subcommittee meeting last night. I'm sure we'll have many more hours of subcommittee meetings and public debate about this, as we should. But just a couple of things. You know, first of all, you know, clearly there's going to be litigation here, and I think we should all be on the same side. I mean, we are the city. We need to go forward. And so I think it's kind of important that we all be on the same side as opposed to not being on the same side. Secondly, when this first arose, that there was a problem with the 3 classrooms, and I've explained it a million times. I'm not going to explain it again. It makes perfect sense in my mind that once those classrooms were deleted by Jackson, they weren't building them, then when if they bought 100 windows for the Stocklosa school, and they left 10 windows out because of those were 3 classrooms, the windows cost $100 a piece in bulk. You know, it doesn't make, you don't have to be, I mean, it's not that hard to figure that when you go back and you only buy 10 windows, the price is going to be more. And that's what the price was. That's how the price got up there. That's why there was an additional cost. I totally agree with Councilor Elliott's point that the 3 classrooms were part of the original contract. Yes, they were. Once they were deleted, then there was a cost to put them back, clearly. You're not buying steel in bulk. You're not buying windows in bulk. Rightly or wrongly, there's a cost to put them back. And we talked about that cost at the first subcommittee meeting when $1 million was added to the bond issue because we didn't have enough money. And I was quoted correctly in the newspaper, believe it or not, that that the cost of the 3 classrooms going back in, I thought was going to be $400,000 based upon what Jackson was telling us. I thought I had the figure at $400,000. Again, let's go back to this to real time. I mean, it's easy to look back on this thing now and say, well, how did this happen? How did that happen? We were trying to get a school built. That's what everybody said. Get the school built. Get the classrooms in. That's what we're trying to do. So we know that there's going to be an added cost. From what I see from the builder, and we couldn't go out and say, Jackson, do you want to build it? Or Fish, do you want to build it? Or Smith, do you want to build it? Jackson was the builder. And Jackson had all the cards at that time, clearly. Because if we wanted those classrooms built, he could have easily said, well, good, here's the plans. They say delete on them. Let's go to court and see her in 2 years, and the Stocklosa school is not built as we sit here today. We didn't want that to happen. Nobody wanted that to happen. So I estimate, based upon what the contractor is telling me, the builder is telling me that's going to put those classrooms back, he's saying there's in the vicinity of $400,000. I also trust the law department. I think Chris O'Connor is an expert in municipal law. I do. And I trust her, and I trust her judgment. And I think she's a great lawyer, and I think she's clearly expert, much more than, I would say, anybody in this room on municipal law. And when Christine does what she does and comes back with a recommendation, you know what? I took it. I thought it was a good recommendation. And the fact that we didn't notify the council, I'm sorry, that we didn't. I was, I thought it was $110,000 savings for the city, and I thought the school was going to be built on time. I really thought that. We weren't trying to hide anything. I mean, clearly it's a public record. There's a settlement here, and I wish we had, because I think if we had at that time, I think this thing would not be being discussed today. So that's where I'm coming from. We're not trying to hide anything. We never have. I think you know me better than that. We were dealing with a difficult situation in real time, not in 2020 vision, looking back. Geez, why didn't this happen? Why didn't that happen? Could this have been handled better? Could that have been handled better? Yes. From the very, very beginning of this whole project, a lot of things could have been handled better. We did the best we could.
Okay, thank you. Councilor Caulfield's been waiting here patiently.
Thank you, Mr. Mayor. It has been a standing joke in Lowell and Greater Lowell. There were 3 classrooms missing at the new Stockloser School. All the talk shows had fun with it. The newspaper had fun with it. And there were 3 classrooms missing. And it was embarrassing. It was embarrassing. Not only for the administration, but for the city council as well. I have records, I don't have them with me, I had them last night. The architect signed off May 24th in the year 2004 to delete the 3 classrooms. I still feel strongly that the Lowell School Committee knew about the deletion of these classrooms because they talked about it many times. Value engineering. How can we cut the costs of this school? We all know that the school was $1 million behind on budget to begin with. And the excavating of the 5 acres was probably the hardest site we ever built a school on, or built a building on in this city. There were 3 feet to 4 feet of soil removed from the site. And we all know that that contractor didn't remove the soil in the proper time, had a problem removing the soil, and then I think it was DEP said we could use the soil as fill. There's nothing wrong with it. But the administration decided we've gone this far, we're going to remove all that soil. And I can still remember the meeting. I think the entire council attended that meeting about bonding for another $1 million. And out of that meeting, I think there was a directive sent to the manager: finish the school. Build the 3 classrooms. Do whatever you have to do to finish the school. Alleviate the embarrassment and alleviate the problem with the deletion of the 3 schools. I think that's what happened, isn't it, Mr. Manager? Was you given a directive by this council to finish the school?
That was my recollection, Council.
Thank you.
Councilor Donahue.
Thank you. Again, not to belabor this, but this isn't about whether Christine O'Connor is a good lawyer. This isn't about whether she does her job as a solicitor. It's about that when we paid $290,000, we didn't have any proof from Jackson. Jackson may have said it's going to cost me more money, but they haven't proved it. You'd agree with me that they still haven't proved it to this day. Isn't that true, Mr. Manager?
And I totally agree with you, Councilor.
Okay. That's what the discussion's about. It's not about, I said at the outset, whether the classrooms were in, they were out, who was right, who was wrong, who's responsible. We could spend a year having that discussion and still not come up to a conclusion. That's why the focus of the subcommittee and tonight is simply, we paid them $290,000 to put it back in, over and above what they'd been paid. The only inquiry is, what did we pay? When we paid them, we had not one bit of proof as to what we were paying them for. That's the inquiry. That's what it's about. We have had reports from subs that they haven't been paid anything. Now, maybe they're going to pursue Jackson. I assume they will, and try and get the money out of Jackson. And that's where we're coming from today. When we paid them in May, we only had from them, this is what it's going to cost, and we paid them. We didn't say, prove it first, we'll pay you later. And there may have been a lot of reasons for doing it that way. But now that the school is built, that they've been out of there, and we still don't have proof, that's why we're getting agitated and saying, what is going on here? What did we pay for? That's what it's about. It's not about getting this, we are on the same page, Mr. Manager. There's no question that we said, get the school built, we'll sort it out later. You know, but this is an issue that we're just looking for, and it's a big one, quite frankly. $290,000, if Jackson wasn't entitled to it, then we want to know. If they are and they prove it, then we move on. That's where we're coming from. And that's the point of the discussion. It's not about, you know, we know that we put the 3 classrooms back in. I'm just assuming for point of the argument that we'll pay them what it was worth just because we already settled with them. we already settled. We already released them on it. All I'm saying is, where's the proof of what they got paid for?
And if I may, Mr. Mayor, Counselor, I couldn't agree with you more. I'm as frustrated about it as you are. I expect to get the information, and I certainly hope that when the information comes in, that will be the end of it, because I'm quite sure that, that the information will be there. I don't think you can put 3 classrooms back, the size of those classrooms with the work that was done there, for a couple of dollars. I'm not a construction engineer. We did, however, to be in all fairness, we did ask DRA, who is the architect, to go to Jackson, and through the actual numbers that the spreadsheet that we've given you, if you look at it, actually came through DRA. They're our architects that we're paying, I don't know, $2 million for on this project to do a job for the city. That question remains open as to how well that was served. But those are the numbers that we had to deal with. I don't know, the classrooms were not built at the time. They were in the process of being put back in. So, you know, I totally agree with you. And I've said this from day one. We are as frustrated as you are in not getting that backup from Jackson. I've talked to them. I've asked them. Christine has. Talked to the bond council. We've talked to everybody we can talk to. We can't force them to give us the information we want. I hope we get it soon, because I hope that will be the end of this thing, when we get that information and they say, here's what it cost us to do that, and that's going to, I hope, and I think, verify what the actions we took.
Councilor Milonazo.
Thank you, Mr. Mayor. Assuming we get that information, Mr. Manager, from Jackson through the bonding company or vice versa, I might have that backwards, who will review it? Is it going to be reviewed in-house, or are we going to hire a third-party architect, say, to review it on behalf of the city?
We will, as soon as we get the information, we will make it available to the council.
Okay. But I guess, I mean, if we still had DRA under contract, we would have DRA reviewed. Obviously, that's not going to happen, because we're going to be in litigation with DRA.
Wouldn't think so.
But again, if you gave it to me, I wouldn't know, because obviously I'm not an expert when it comes to, you know, additions, deletions, when it comes to contractors, contracting items.
Right. Part of this, too, is it's all being filtered through a third party,
Okay.
i.e. the bonding company. And they have a financial interest in this as well. And they have a financial interest in making sure that, you know, that payments are accurate, that they're accurate. And so, again, having spoken to at least the contractor from the bonding company who had contacted me, and this is the second time that they've contacted the law department, they're well aware. They have been fully apprised by Jackson as to the issue surrounding the 3 classrooms. They've been fully apprised as to Jackson's obligations pursuant to its settlement to produce these documents, and at least the indication that I got today was that they've confirmed that they do have all of the construction documents pertaining to the Stocklosa School, which again involves their money as the bonding company. And the impression that I got from them today is that they will be complying with that directive, that all of that backup documentation supporting the initial cost of what it would have initially cost to build these classrooms, plus the additional cost as the result of the significant lag time will be provided. And
should the
we'll know more. We'll get a much better sense, I think, by if we have that meeting next Thursday, then we'd probably be able to update the council either by your packet on that following Friday or the following Tuesday.
And I trust that the bonding company is going to look at the whole package relative to the retainage dollars that is still outstanding. And at the end of the day, they'll give a report to the manager's office, to the solicitor's office, as to what ultimately will have to be paid to close out the project as well.
Yeah, I mean, these are all the issues that we'll be going through, in some respects. Unfortunately, in some respects, fortunately, with the bonding company. There are some benefits to going about it this way. And, but anyway, that answers your question, yeah.
Okay. Councilor Mercier.
Thank you, Mr. Mayor. Just one question. The DRA is the architect hired by the city to be part of this contract, right? And so they're not exempt from any potential liability here, are they? I mean, they're still on the hook here for the responsibility of what's happened here. Am I right?
One thing that, yes, Council, one thing that specifically happened through mediation is we retained all of our rights against DRA. Clearly, they didn't sign the settlement because the settlement Well, they didn't sign the settlement, nor do we want them to sign the settlement. We retained all our rights against them, and we also picked up all of Jackson's rights against them. So clearly, we are well-positioned as far as that is concerned.
And is that the litigation that you made reference to before, that we can't get into?
Right. I mean, they're
Okay.
most likely, unless there was some settlement, which, as I had indicated previously, if there was some settlement offer, that would be taken to the council in executive session. But absent that, there would certainly be litigation against DRA.
Thank you.
Okay. Counselor Elliott, do you have a question?
Thank you. I know we spent a lot of time on this, but if we went into mediation and we came out with the $290,000 figure, when DRA, and that's why I made the motion to make sure DRA and Mr. Souza that they're present at the meeting, because we've been meeting, the manager and the solicitor and the subcommittee. We don't have the parties that were actually on site. We had Jackson at one of the meetings and DRA, but there was very little discussion with those individuals that presumably made the decision, i.e. the architect made the decision to take it out. If that was the case, and you indicated last night they stamped delete over the area of the classrooms that were supposedly taken out, where is the supporting document, i.e. the change order that said we're taking them out, it's going to save, I guess, $290,000 or less at that time? Where is that information? And
There were change orders, well, a couple things. One,
I mean, if they took it out, they said you're going to save this amount of money because that's what we were going through. There was a shortfall. But I still maintain, like the manager said, they bid on something. It included those classrooms. If someone told me to build a house with 3 bedrooms for X amount of dollars, then I'm going to build it, unless they say take it out and they're going to get money back. And I don't see that we get any money back, and they were still obligated to do that. That's what is the difficult issue to understand. So I interrupted you, I'm sorry, but they took them out, so do we get money for it?
I mean, that's the suit against the architect. The architect, initially they were later plans don't even have this information in there. I mean, the classrooms don't even appear in those plans. I mean, you're talking about plans
and I just want to follow up from last night. Now, Jackson Construction, this is not the first school they built. It's not the first public construction project that they've done. They know the change order or change directive. If they didn't have that executed document, why would they do that? That's less money for them and part of their contract. They're not going to get a credit for it. So why would they not proceed with that? That's what I just can't get.
Sure. Couple of things. One, these things did not just affect Jackson. It affected every single subcontractor. I mean, you have your electrical engineers. They have their plans that they have to go to. None of these subs had any plans that included, at some point in time, these classrooms in them. They were just all gone. So it wasn't even just Jackson that is not building the... I mean, there was just nobody involved in this project. They just weren't there anymore in the plans. As far as the change order, yes, that would have been the normal procedure. And apparently, at one point in time, it looked like that the parties were very close to a number, and they were closing in on it, so to speak. And then eventually, the gap, instead of narrowing, actually increased. And at that point, eventually, there was what was issued a CCD. And again, 2 things, as I was saying last night. The construction documents do become part of the contract. That is one of the things that becomes part of the actual contract. So, yes, you bid on your contract, but and including these construction plans. But these plans were stamped by an architect, and beyond that, the architect is also throughout this process certifying to the auditor's office each and every payment to Jackson, and in so certifying, they are certifying that this school is being built in accordance with the construction documents and the plans. At a later date, now technically that was not correct, and it was not correct of them to do, and that's our position. At a later date, there was executed a CCD, which then formally completely eliminated these classrooms. By the time that occurred, however, and the parties don't have to come to an agreement, the contractor doesn't have to sign it, but at that point, again, the classrooms had long since disappeared from construction.
Okay, thank you.
Okay, Councilor Broderick.
Thank you, Mr. Mayor. Through you to Madam Solicitor. Just two questions, I hope. The agreement, the settlement agreement, the release, we brought this up last night. It refers to the fact that they have to cooperate as part of the agreement and produce the documents. That's my first question, so that was an easy one. The second question is, at what point are they in breach of the agreement? And we simply say, give us the money back.
Correct, and it's a fair question. As I was saying last night, I don't believe that we're at that point yet. Again, we have, they're going through this process with their bonding company. The bonding company is basically in charge of the documents. They're in charge of Jackson. They're in charge of this project once they formally take it over, because again, it's their money that also is going to finish it up. If there wasn't enough money, the bonding company steps in place. They have apparently settled with a lot of the subs on the job. Subs have been paid, and they are aware of their obligations, of Jackson's obligations pursuant to the settlement agreement, and they're also aware that it's the city's position that if we weren't if they don't comply with the terms and conditions set forth in the settlement documents, that we would consider them in breach, and we are again holding roughly $1.1 million of their funds. So the short answer is I don't believe we have yet gotten to that point, because the indications from the bonding company are that they're aware of it. They're indicating verbally that they're intending to produce those documents and comply. In the event that that doesn't happen, then we get to that step.
Thank you.
Okay. Councilor Donahue, I think you had a motion concerning Mr. Souza, whether he was to appear. Did you want to wait until the timeline was?
There were two motions. That one asking for DRA and Mr. Sousa to appear. But it would seem to me that we had a motion for a timeline,
Right.
and now based on what the solicitor has indicated, that the solicitor expects to have backup documentation soon, then it would seem to me that rather than have people come to a meeting and then have to come back to a meeting, wouldn't it make sense to get all the information first, and then I'll renew that motion at a later date once we have all that information, if it's coming in the near future.
Right. Just to be, if I may,
Madam Solicitor? Yeah.
Just to be clear on that, I agree, and they haven't given me a timeline as to when they'll actually get that information to us, but that's exactly what we intend on going over in that meeting on Thursday, assuming that takes place on that day. And part of what we would go over pursuant to that meeting would be a timeline as to this and many other issues.
Well, it would seem that it would,
and
is that this Thursday that you're meeting?
No, it would be what they've proposed, when they called today, they proposed a week from this Thursday. And so we're just going to check with people's schedules and do everything possible to make sure that happens.
Then I would, again, it was Councilor Elliott's motion as far as with the extent of the maker of the motion, I would suggest that we defer any action or presenting that to the full council until the full council has all the information. Let's put a time frame on that. Maybe let's have an update in 2 weeks from the solicitor as to where we stand in terms of the documents and the timeline, and then we'll take up the matter at that point. But I don't think it makes any sense having these individuals come to the next meeting when we still don't have the information, and we'll say, why don't you keep coming back? So, I think in the meantime, though, maybe if the solicitor thinks it's appropriate, whether because of pending litigation, well, strike that. Just invite them and see where it goes.
Okay. Motion to accept the report of the subcommittee as a report of progress by Councilor Donahue, seconded by Councilor Milanazzo. All those in favor of that motion say aye. Any opposed? The motion's adopted. I think we have a request to take an item out of order here.
I have another subcommittee.
Well, can we do that after this?
Oh, yeah, sure.
Okay.
Yeah.
I didn't realize this discussion would be so long. There are people here to speak on Councilor Caulfield's motion So if we could have a motion to suspend the rules to take that out of order by Councilor Milonazo, seconded by Councilor Caulfield. All those in favor say aye. Any opposed? That motion's adopted. The motion by Councilor Caulfield is the City Council requests the manager and the Division of Planning and Development research various grants that would help renovate the Brady School on Pine Street. Motion being brought forward by the Friends of Tyler Park. Seconded by Councilor Elliott. There are some people, I think, registered to speak. We want to hear from them first.
Yes.
Okay. Jay Mason, if you could just recite your name and address for the record, please.
Thank you, Mr. Mayor. My name is Jay Mason. I reside at 77 Tyler Park in the Highlands. I actually would like to introduce someone much more important than myself with respect to this matter, someone who has quite a great deal of history and interest in the city and particularly in this building, Mrs. Margaret Brady.
Okay. Mrs. Brady, our apologies for keeping you here this late, but we're happy to hear from you.
Officially, my name is Margaret R. Brady, 17 Oakland Street. Unofficially, if you hear some snoring, you'll know it's me because I'm usually in bed by 8 o'clock. That's what you can do when you retire. I don't know what is planned for this school, this building. I don't know much about raising money for grants. I don't know much about architect. I only know it from a personal point of view. I know a number of you people who are here this evening, especially Mr. Milonazo, because his wife taught with me at the Pine Street School. I know it's called the Brady School, but for all the years that I was there 18 years. It was always the Pine Street School. So I always refer to it, even though I know it's been renamed. I can give you a little personal background on this, and then the other fellows will take over on how you're going to raise money. I'm a child of the Depression years. My sister is 4 years older than I. She went to school with K. Stocklosa. My brother attended the Pine Street School, and I was in the first grade when my dad died, and he left 4 children. In those days, you either went on the dole or you went to the orphanage. My mother chose the orphanage for us. It was called St. Peter's Orphanage, which is now the main building of Lowell Catholic on Stephen Street. 35 years later, I was elected the teaching principal of the Pine Street School. And as soon as I got the keys, I got up to the school, and I got the mass teachers' registrations of attendance, and I looked up my name, and it was like coming home 35 years later. I was there for 18 years. I lived just around the corner, and I'm still just around the corner. I used to walk my dog. I would know the children who were born before they were born because I knew the parents. Sometimes I would give a little threat, and I say, if I see you do that again, when I see your mom and dad and I'm out walking this afternoon, I will speak to them about it. Well, it would soon stop. We had approximately 200 students. There are 4 buildings, 4 rooms in the main building, and at the time, those little trailers had been added to the back of the building, so we had 6 rooms. A teaching principal is one who teaches full-time every subject and is also principal of the building. In that position, I think that is what is making the Pine Street Brady School unique right now, because it is the last of them. It is a historical building. I don't know who would want to come visit it. I never thought that anybody would come to want to visit, God forgive me, downtown a few years back, but the town has taken quite a turn for itself. It would be nice if You look at Tyler Park, which was built by the Olmsted fellow, and they have concerts and they have just wonderful times. Years ago, that was just like a weedy old place. Something can be done. We didn't have storm windows. Snow used to blow in during a snowstorm. We'd be sitting in the corner having a reading group, and if the storm was bad, the snow would blow in under the windows. We had one plug for each room. We had the bathrooms downstairs, boys' side, girls' side, that had the bathrooms. They had the pull chain. Those are long gone. The bell for the outside recess broke one time, so my janitor got a great big ding and ding and ding. Has the history of a time gone past. The school did its part. I looked up the Spanish influenza, saw the number of children who died. It would be they would be there and then absent and then passed away. We have pictures of the building. Somewhere along the way, I don't know what year it was, they placed that asbestos covering on the building. We had almost 200 children. We had a number of teachers for about 50 years, and we lived with that. None of us came down with tuberculosis or any of the other things lung diseases. But when it was closed and the health department moved in, it was considered very unhealthy. We lived with it, though. It has changed, and it hasn't changed inside. I don't know what is going to become of the building, whether the health department will stay there or will not stay there. But it's a wonderful, old, strong building. And it's just part of the history of the Highlands. And we had the Panagiotakis and Zames and Schofields, and we had Studleys, and we had Dailies, they're doctors. I have one who's, she has received her doctorate from Cambridge, in Oxford and Cambridge, England. Of course we have the ones in the day-to-day column too, but, we don't talk about that much. 3 present policemen on the Lowell police force. It was like a home. Every teacher in that building knew every other child in that building by name. No teacher resented it. If somebody went by and was doing something they shouldn't, and you stopped and reprimanded that child, the other teacher would say, "Thank you. That was well done." It was like coming home. It was home to some of these children. We were some of the only people who were interested in some of these children. If the building is ever closed, it would make a nice drop-in center for the elderly, myself. It would make a nice neighborhood library. I love to read. I hope I pass that on to the children. I can't get down to the downtown library. It would be wonderful if we had a neighborhood library. It could be a computer center for the elderly. Could be a computer center for the young. Could be a library for the young. There's many possibilities to it. I don't know what's going to happen to it, but I do hope that she's kept and repaired. During the Second World War, they had placed for those of you who don't remember the Second World War, they had placed a air raid siren on the top of the building. And they used to have the air raids practices every so often. And the children used to hide under the desk and the air raids would go off. It was removed eventually because it started to topple. She is now beginning to topple on the outside. I am very fortunate in that I am a retired teacher from the city of Lowell and the school department has given us the benefit of Blue Cross and Blue Shield. A replaced knee, a replaced shoulder, spinal therapy, curly hair. It would be nice if somewhere along the way money could be found to decorate her up a little bit, fix her up on the outside. She may be falling apart in the inside. We don't know what's going to happen to her, but wouldn't it be nice if we could make her into a grand old lady again? Thank you.
Thank you. Thank you, Mrs. Birdie. Mr. Mason?
Thank you, Mr. Mayor. Distinguished city councilors, City Manager Cox, I'd like to start by distributing some photographs of the building so you can have a little bit of an aid to, a visual aid to our, and I'll make them brief comments. The Brady School is an outstanding example of a colonial revival wood frame school building, typical of this type of structure built throughout the United States in the late 1800s. This particular building was built in about 1896, 1897. And it's interesting to note, it was formed out of a little bit of controversy. There were poorer sections of town that wanted school buildings built at the time, but the Brady School did end up getting built for the amazing sum of $23,304.37. So we're trying to leverage that investment tonight. Due to the city's renewal project for the building several years ago, a couple years ago, and unfortunately never completed, the Brady School is in decline. Presently, the exterior is missing a skin of wood siding and much of its protective wood trim. The result is a shabby appearance, and perhaps more critically, the building is exposed to the damaging effects of wind and snow. Similar to a body without a complete covering, the Brady School is vulnerable to its environment. Mold, rot, and wood damage can all work behind the scenes, unseen, weakening and deteriorating the building from the inside out. The Friends of Tyler Park and other concerned citizens are here to present an opportunity to provide the necessary planning and repairs to save this fine building from destruction and ultimate elimination due to these environmental factors. The motion before you, Mr. Manager, provides for planning and construction work. The planning would protect the city's investment by establishing guidelines for the contractor to follow. Based on the U.S. Secretary of the Interior's guidelines for historic structures, which the city has used on many occasions, the guidelines will ensure an appropriate scope of work as determined by an experienced professional planner or architect and compatible bids from contractors based on clear and time-tested instructions for similar projects. The guidelines will also keep the costs to the lowest amount possible by allowing competitive bids on a uniform set of instructions. The construction work would be broken out into two phases: stabilization and restoration. The two-phase approach would allow the immediate implementation of the repairs necessary to triage the building and stop the bleeding. In other words, provide critical repairs necessary and then provide for stabilized conditions until funds are assembled to perform the restoration. We know this project could cost anywhere from $50,000 to $250,000 to do properly, and we want to understand how to best do that by getting somebody in to plan the idea first. We're not going to try to do this without thinking it through clearly and carefully, first pass. The full restoration of this building is the goal. The Highlands of the Friends of Tyler Park and the Highlands neighbors here tonight, and I want to thank each and every one of you for coming and showing support and being, our backbone. We can't do this alone. We're a partnership. We're a collaborative. The city, the neighbors, the citizens, the voters, and we're here to make something happen as a group. We can look away from what's happening here at the damage. The urban blight will simply continue. If we partner together, we can save this building, and in so doing, save a vital corner of our past as well as our shared future. it's not going to be any less expensive to act later. In fact, I know as a professional in the field that it will only get more expensive as time goes on, given the conditions that are out there that you're looking at in those photographs. So I hope you will join all of us here tonight and pass this important motion. Now, the motion, I haven't read the final draft since I gave it to Councilor Caulfield, but I did want to add one final thing here. The Friends of Tyler Park have investigated some funding sources. We know this isn't a time of excess in the city coffers. There are, among others, the Massachusetts Preservation Projects Fund, the Certified Local Government Project Fund through the NPS, National Park Service, the Historic Preservation Fund grants, and also there is possible funding for planning through the Preserve America grant. So with that in mind, I'd like to let a couple of other people speak, and I thank you very much for your time.
Thank you, Mr. Mason. Mehmet Ali is registered to speak, but I don't see him here. How about Dennis McEnany? Am I saying that correctly? McKeevy? Not here. Those are all the people we have registered. McCarthy. Dennis McCarthy. Sorry.
Thank you, Mr. Mayor. I'm a resident of Lowell for the last 45 years and lived in the Highlands neighborhood for the last 20. And the school is really an icon of the neighborhood. It represents almost the counterpoint of Tyler Park, and when it got the siding removed a number of years ago, it was my hope that it was going to continue coming back, and it's just sat there. It really is a little distressing to see a building of that stature left in its present state, and I just hope the city sees it necessary to restore it, at least bring back the exterior shell and maintain it, because it is really an icon for the neighborhood. Thank you.
Thank you. Councilor Caulfield.
Thank you very much, Mr. Mayor, and I want to thank my colleagues for allowing this motion to be taken out of sequence. And first and foremost, I want to thank Margaret Brady for being here with us this evening and giving us an eloquent presentation of a great school. And the school might be built on Pine Street, but it will still and always will be called the Brady School. And I also want to thank Jay Mason and the Tyler Park Restoration Organization for working tirelessly, not only for Tyler Park, but for this project as well. I want to present to the clerk a letter from Senator Stephen Panagiotakis indicating his support for the renovation of this school, and I will forward this letter to the clerk to place on file. As Margaret Brady indicated, this is a great building. A great building because of the students who went to that school, were educated at that school, the teachers who were dedicated presenting that education. Now the school is in disarray. And Mr. Manager, I would have to indicate that if this was a landlord in the city of Lowell, there'd be various motions filed by members of the council for the city to do something about it. And we all know that. But we also know we need funds to address this. And I know we have some excellent craftsmen in DPW who could refurbish that school if we came up with the necessary funds. And Jay Mason indicated the Massachusetts Preservation Project Fund, the Certified Local Government Program Fund through the National Park Service, the Historic Preservation Fund grants also through the National Park Service, and a grant from Preserve America could be used for research. So I think the gist of the motion, Mr. Manager, is requesting your administration, DPD, to turn over every stone and find out what we can do to preserve this great building and preserve the memory and the name of this school that was so great to the youngsters in the Highlands. And as Margaret Brady indicated, many of the youngsters who are now serving in public service in the state, in the city, and so forth, were educated there. So that is the gist of the motion. I know this has been brought forward before, but I don't think it's ever been brought forward with this magnitude. And on behalf of Margaret Brady and Jay Mason and the entire Tyler Park District and the Highlands, we would like to see something done to come up with the necessary funds, Mr. Manager. Thank you.
Okay, thanks. Councilor Milonazo?
Thank you, Mr. Mayor. First of all, it's delightful to see Ms. Brady here this evening. I know that when my wife worked actually with Ms. Brady, it was really wonderful years that she looks back on, and I'm just thrilled to see her this evening. And I think that she deserves better, talking personally for a minute, that she deserves better than this building that obviously is now falling down. And we need to be able to work with various funding institutions and work with the Friends of Tyler Park to actually help renovate the property. I would suggest that we also reach out to the vocational school as a suggestion. They might be able to provide us with some staff, if you will, or some laborers to actually work on the building as well. And I believe Congressman Mean was actually announcing today a youth build grant for some property over on Worthing Street. And maybe there's an opportunity for the youth build program to get involved in this building as well, because clearly it's had just a tremendous impact on that section of the Highlands neighborhood. And I just think that we really need to be able to really, as a tribute to Miss Brady, to really renovate this building to the stature that it once was. And I also want to say that a friend of ours, a friend of mine, Bob Gilman, who lives up in the neighborhood as well, has called me a half a dozen times on this building, and I know that he would stand ready to help in any way he could in any effort that is really put forth to save and renovate this building. So again, I want to congratulate Jay Mason and the Friends of Tyler Park and Councilor Caulfield for bringing this forward. I really think it's very important that something get done very quickly, actually.
Thank you. Councilor Rita Mercier.
Thank you, Mr. Mayor. It is very nice to see Margaret Brady here gracing our council chambers this evening. And I did bring forth a motion some time ago to preserve the name and keep it there. When they were taking the asbestos off, we thought they'd be removing the name. So it's nice to know, to have you here, that your namesake will be up there forever and ever. But it's such a disgrace to put the name on the building the way that it looks now. So this is a very timely and precise motion on that end. And I'm always ever so vigilant to realize that this city has like a motto that we like to preserve that which we own and maintain that which the city owns. This would be quite evident there. And I believe that whoever hand goes up first says just what I'm about to say, but DPW's land and buildings could be coming on board, as well as CTI's youth build. So there's an avenue there for a campaign of teamwork, and we could get them all together and, like it's called, like a bond raising or some sort of thing like that, where we all come together and for the greatness of a neighborhood, to preserve the integrity of a building, to restore the dignity of a neighborhood, and to make right the namesake that's on that building. So I'm very happy about this motion. I wholeheartedly support it, and I know it can be done. I have the faith to know that it will be done. And I know, Mr. Manager, they didn't just come here this evening with a request. They gave you a number of places where we could look for grants. So thank you very much for being involved in making a partnership work. Thank you.
Thank you. Okay, anyone else? All in favor of the motion, say aye. Any opposed? The motion is adopted. I want to thank everybody for attending tonight, and sorry to keep you here so long. Okay. Next item, I think we're back to subcommittee reports. Councilor Donahue.
Thank you, Mr. Mayor. The next subcommittee report is the Technology Subcommittee met this evening. I'll make this report brief. We were asked to take up a couple of matters. One having to do with a motion that had been made by Councilor Ramirez for us to, the city to look into providing Wi-Fi or wireless internet, or investigate the possibilities. And the other came actually from constituents who had sent emails asking if the city could provide more information on our government page, including pictures of counselors, biographies of each one, subcommittees they belong to, and so forth. As to that first issue, I believe all of my colleagues have received a request from the mayor's office and MIS asking to provide a picture. You didn't get that? Okay, they're waiting for a picture. Okay, so if I, you know, some people have given them in and some haven't, and I'm one who hasn't, and Rita's one who hasn't. So what MIS would like to do is put as part of the government page pictures of counselors, some biographical information, including information as, you know, subcommittees that they may sit on, so that the public can find out who's sitting on which one. Sometimes it's hard for us to remember who's sitting on what ones. And also contact and what's the best way of contacting them. Some people prefer email, some people prefer telephone calls, and if it's right on the website, this is, you know, the best place to get in touch with me, then the public knows, you know, on that. Moran asked if we could get that information to him ASAP, then he can complete the process of updating that page. And in the timeline that he gave us, you know, they were hoping to do that by April of 2006. So if we can get that out there, then the public can get that information. Another request made was that if subcommittee notices could be posted on the web. They aren't at this point, but the clerk was present and said he certainly can do that. Again, the public that way now they can get the agendas of the city council meetings on the web, on the city website. They can also then get notices of subcommittee meetings and what is going to be discussed. And so that's something that was an easy answer. It can be done, and it will be done in the very near future. The web is also providing for you know, the agendas and so forth, not just of the council, but the planning board, the licensing board, and everything that can be obtained on the website. There was some other information provided to us regarding the city website, and I won't bore you, but it was kind of interesting. You may be interested in this, Mr. Manager, in terms of the hits on the city website for the month of February. If you look at the chart, and it's used quite a bit. The week up to in the weekend of Winterfest, the spikes, I don't know if anybody can see this, but the spikes are enormous in terms of hits on the website. So what that really does show is that, you know, people are using the website, not just within the city, but to get information. Like, we can only surmise, why would it be that weekend? But there's an activity in that people are looking to the website. So it's a very good tool for the city, and it's showing that people are using it in and around activities in the city. The other issue, I'll run through this really quickly, because the other issue we took up was wireless internet, trying to explore the possibilities of the city providing that. That's something that some cities have done, larger cities in the country, some with success, some with failures. Moran is looking into that. It's a very complicated and can be costly process, but it's a great idea to provide this, and Councilor Ramirez brought that motion again to get the city exploring this, and MIS will be exploring it and coming back to us with some information. One of the things that they're also working on is, for example, they could put a link on for those particular businesses in the downtown that already have wireless internet, and maybe for information, not advertising, but direct people, so that those who like to use their laptops if they go out for a cup of coffee could click on and find out what places in downtown Lowell they can do that. That's something that can be done. And other things that that MIS is working on, including a project with the university, what are called hotspots. In other words, kiosks, information that someone can go to and just kind of click right in and find out what there is where to go to eat, what's happening in the city, and from an internet access point of view. So there is a lot of information, and there's a lot of research going on as we speak at MIS. And in addition to all the many, many, many websites that they are monitoring and providing work on. So that's a report of progress. I expect that we'll get information back in the future from MIS about the Wi-Fi or wireless internet, but I just remind my colleagues to get your information to MIS so that they can update the webpage.
Okay, thank you. Motion to accept the report as a report of progress by Councilor Rita Mercier, seconded by Councilor Ramirez. All those in favor say aye. Any opposed? The motion is adopted. Under petitions, we have one petition from Verizon requesting 15 feet of conduit in Watson Street. That's to be referred to a public hearing on March 28th. So moved by Councilor Armin Mercier, seconded by Councilor Rita Mercier. All in favor say aye. Any opposed? That motion is adopted. We have one claim for personal injury to be referred to the Law Department. Motion by Councilor Ramirez to do that, second by Councilor Milanazzo. All those in favor say aye. Any opposed? That motion's adopted. We have three miscellaneous requests, petitions for handicap parking signs. Motion to refer to the traffic engineer by Councilor Broderick, seconded by Councilor Ramirez. All those in favor say aye. Any opposed? Those motions are adopted. And we have a request from Keyspan to replace a gas main in various streets in the Pawtucketville area as part of the sewer separation project, to be referred to a public hearing on April 4th. So moved by Councilor Elliott. Do you have a question on that?
Not related to this, Mr. Mayor, but when I did see this, it just sparked my interest that work is going to begin with the sewer separation project up in the Pawtucketville area that we, that we approved quite some time ago. So I thought it might be appropriate to have maybe Mark Young come in and give a presentation as to when it's going to begin, and I'm sure they'll go through a public hearing, but when I saw all these streets, and I just thought it might be a good idea to let people in that neighborhood know we made our promise, we're fulfilling our promise, and this is the time frame that you can expect to see something happen. So just a thought.
I believe, Council, that I read something today from Mark Young that'll be in your packets next week pertaining to when the work will begin and everything. So a very timely comment, because I believe I read something today that's going into the packets for Friday.
Okay.
For 6th and Emery.
All right, thank you.
Okay. Motion to refer that matter to a public hearing on April 4th by Councilor Elliott, seconded by Councilor Rita Mercier. All those in favor say aye. Any opposed? That motion is adopted. Under the motions, Councilor Rita Mercier.
Mr. Mayor, I'd like to move for a point of personal privilege on a particular matter that took place last Wednesday, if I could do that.
Okay. Chair recognizes Councilor Rita Mercier. Point of personal privilege.
It seems sometimes that we have very busy weeks, and we always talk about a lot of controversy that goes on. We always hear the bad news. I want to talk about a little bit about a particular happenstance and what came about it. Last Wednesday evening, I received a call from a concerned resident who informed me about an emergency situation of a family with 4 children being put out of their apartment due to National Grid shutting off the electrical power to their house. Therefore, they had no lights or heat, and they were forced out into the street. The caller was the next-door neighbor who had taken them in and out of the street. She was asking me what I could do to help in this particular situation, and since it was after hours and the city hall was closed, I called the police department, and I got a hold of a Captain Kevin Sullivan, the shift commander. That was the best call that I could have ever made, because this officer delivered. Before the night was over, and Captain Sullivan did call me after the end of this whole fiasco, after I had called the police department, before the night was over, Captain Sullivan had the police department there at the scene. He had the building inspector, David St. Hilaire, there, Deputy Chief Finnegan from the fire department, and National Grid was back. National Grid, Mass Electric, same difference. And the Red Cross was there as well. When we talk about team efforts, and we just had the Friends at Tyler Park here, I know that things can be delivered because people are concerned and they do things to help one another. It seems that the house was foreclosed upon and the owner lost the house. The house was acquired by a bank who hired a management company to handle the affairs. Finding it difficult and lengthy to evict these tenants, someone connived a plan to remove the electrical box, and then someone dropped a dime to the inspector who contacted Mass Electric or National Grid. Thus, they deemed the property uninhabitable, a fire hazard, unsafe for this family, and they were forced into the street just to do nothing but be out into the street. But with the help of the above-mentioned people and the team effort that was so nobly displayed, I want to publicly say thank you for a job well done. This family was put back into their apartment. It seems there were not 4 children, but 9 children. There were 2 families involved, 1 on each floor. The electrician from Mass Electric National Grid took 2 hours to repair the electrical and took $30 out of his pocket to purchase a cover to put over the electrical box. This man was Brian McNeil, and I want to again say thank you to all those that assisted preventing 2 families and 9 children into the street, as well as the next-door neighbor for being so kind to take them in and to call me in the first place, and to Captain Kevin Sullivan for a job well done. There is a lot to like about Lowell when you have people so great as this that care about one another to get them involved and get them back into their home. And I'm telling you that I say this with the coincidence that the Friends of Tyler Park came up, and I know we can do things like such as this magnitude when we all stick together. So I want to say thank you to all the people that have a job and go above and beyond their duty to make things happen for people. Thank you.
Okay, thank you, Councilor. Under the motions, the first motion is by Councilor Elliott. City Council requests the city manager have the Parks Commission and Parks Commissioner develop a fee structure and use policy for city parks, including the new field at Colley Stadium. Seconded by Councilor Broderick. Councilor Elliott.
Thank you. I expect maybe this will go to Councilor Mercy's subcommittee, but with the, I know that beginning construction of the new Colley Stadium and the turf field, and my understanding is there's been a number of, quite a few requests for use of that field. And so I thought it was appropriate to put a fee structure in place. And the second motion sort of accompanies it, supports it.
Do you want me to read that one?
I think it does go along with it that we set up a fund. Yeah.
All right. The second motion is a request by Councilor Elliott, request the City Council Finance Subcommittee meet relative to establishing a revolving fund for the expenditure of park fees. Seconded by Councilor Donahue. Councilor Elliott.
Thank you, Mr. Mayor. Just to follow up, and I will be brief, but it's just setting up a revolving fund, whether it's Colley Stadium or any other park for that matter. I mean, there's overtime and maintenance, and not so much in the turf field, but you know, that field is set up to be used 7 days a week, and that's why we're investing in it. So I thought before the whole permitting process comes in, we set priorities, including some of the other fields. I know there have been requests for, you know, semi-professional teams to use some of the fields, and one in particular is Edward Street. Well, in my opinion, that it's used and should be used just for youth activities and youth sports, youth soccer. And I think we need a policy in place. We're not trying to, you know, discriminate against any other group, but soccer and football in particular, you know, the grass needs some time to grow. So I don't want to get into a long discussion on it, but I think it's important that we do set priorities. So the Parks Commission and Parks and Rec Commission, they know how to allocate these permits, because there is only so limited space, and there's a lot of groups that want to use that space, and we have to set some priorities. And those professional groups that want to use it, they have to pay for it. So that's really the gist of the motion. What this motion is not about is charging youth organizations, by the way, to use the field. I need to be clear.
If I may, Mayor.
Mr. Manager.
Thank you. Tommy Belgard and I have already talked about that as far as Colley Stadium is concerned. Clearly, we think that there will be a huge increase in requests for Colley Stadium, and so Tommy is working with the Parks Commission already to begin to look at those fees. As far as a revolving fund, that's something we can certainly talk about and put into effect if the council so chooses. And the good news is work has begun on Colley Stadium. The resurfacing of Colley Stadium work began today. They're a little ahead of schedule, and we look forward to a completion sometime in around before July 1st. So we're looking forward to that.
Okay, thank you.
Thanks. Councilor Rita Mercier.
Thank you, Mr. Mayor, and I am looking forward to discussing these three motions before us. As far as developing a fee structure, there already is a fee structure in place. It's a $10 per 2-hour time block for organized leagues. So I'm asking the maker of the motion, are you requesting for these fees to be increased?
I think that's appropriate, yes.
You do. All right. And secondly, there already is a use policy in place. Lowell High School has first preference on all fields. Lowell Catholic is second, and then the leagues may use the field next. So if you want to, we will discuss all these. As far as a revolving fund, I would like to refer this motion first to the law department to see if this approach would be legal. In some forms of government, you can't just establish a fund separate, such as this. I don't know if you can, so I wouldn't say we're going to do it. It may be a law that dictates this fee money go into the general fund and no place else. I don't know that. So before we discuss this, I'm referring this to the law department, because I don't know that you can just do that.
Right, I just took a quick look at it today. It looks actually as if a revolving fund had already been set up for this. And this also looks like it's the narrow exception that this does not have to be reapproved every year as all other revolving funds. So again, I just took a quick look at it, but we'll certainly get you a full report on that.
Sure.
And if that's the case, why this is the exception.
Right. Thank you.
Councilor Caulfield.
Thank you, Mr. Mayor. Just very briefly, I know for a fact that there are many youth organizations that use Colley Stadium and will continue to use Colley Stadium, hopefully, Mr. Manager, at no cost, Pop Warner football, etc. Also, Alumni Field, very well groomed, taken care of. I believe the American Legion and other baseball entities use that facility. And I would not support any fee or charge to the youth organizations, as Councilor Elliott indicated. But for those organizations that are charging a ticket, charging a price to go in, we should charge for the use of the field and for the upkeep and maintenance of that field.
Councilor, I totally agree, and the discussions I've had with Tommy Belgard have been in that regard. Clearly, we expect, the Dead Martin Sports Complex will be after the installation of synthetic turf, one of the best. Yes. Certainly in Massachusetts, not in New England, and so we expect much. There is already anticipation. The softball field. Clearly, we're not looking to make money off youth groups in the city, but when other groups come in from the outside and want to use this facility, we need to have a realistic fee schedule in place, I think.
Okay. Thank you. All in favor of the motion say aye. There's two motions, one to be referred to the Parks Subcommittee, one to Finance. All in favor of the motion say aye. Any opposed? Those motions are adopted. Next motion by Councilor Elliott. The City Council requests the City Manager, City Council, Parks Commission, Commissioner, and the Public Works Department investigate using the cap landfill for a recreational snowboard park. Seconded by Councilor Caulfield. Councilor Elliott.
Thank you, Mr. Mayor. This is just an idea. I know the landfill has been capped for, I think, 10, 11, 12 years, and I know there's a methane extraction system that's in place. I just, if you don't throw an idea out there and you don't try to look into it, then, we'll never get the answer. I guess we need to find out how much methane really is coming out after all these years. I know that the landfill does shrink, or it goes down at least around a foot a year. I'm sure there's some safety issues that we have to look at. I don't know if all the valves are working and if methane is coming out, but I did want to look into it, because you drive by it and you look for, in the middle of the winter, we talk about, things for kids to do that's affordable, and we have quite a piece of quite a large piece of property. What can we do with it? You know, I know there's many landfills that are being converted to soccer fields or golf courses or driving ranges. That doesn't seem to be a fit if you drive in and you see, you know, there's not a lot of space to lay one of those out. So it was just an idea. I think it can work. I don't know how much methane is coming out of there and if it's even generating, you know, producing any electricity that was intended to do. My understanding is that it isn't, but if we can get a report from, or maybe the manager knows from Mr. Walsh. But, I mean, let's look into it. You know, in the middle of winter, kids can't afford to go all the way up to the mountains or somewhere else. They can go right in the city to do some snowboarding. Maybe it'll work.
Well, Council, very briefly, my understanding is that methane is still coming out of that. We still have the wells there and the piping and what have you. But we'll certainly look into it, and you could certainly be the first person down the mountain on a snowboard.
Councilor Caulfield?
Thank you, Mr. Mayor. I'd like to refer this motion to the manager and Ed Watch, DPW. When we closed the landfill, it cost approximately $5 million. And this was brought up many, many, many times. And the engineering staff, I think it was Rust Engineering, there's a membrane over that entire landfill. And recreation was not recommended for any use. And furthermore, the landfill is completely fenced in. So if we allowed it for recreation, you'd have to have the gatekeeper there or someone to let youngsters in and out and so forth. But refer it to Ed Walsh and the manager and come back with a recommendation. Thanks.
Councilor Elliott?
I mean, I agree. I know there's a membrane on it, but, you know, after a period of time, landfills are reusable. I understand Councilor Caulfield's concern, but, you know, we're not going to be driving tractors over it. Just kids are going to be skateboarding. So, you know, I understand his concern, but I hope that's not going to be an impediment to, you know, giving, I don't know, hundreds of kids a chance to just, you know, snowboard down a hill.
Okay. Councilor Rita Mercier?
Thank you, Mr. Mayor. I can recall this motion before us years ago because I made it some time ago, and I was told at that time that because of the pipes sticking out these pipes were releasing methane gas, it would create a hazard and a liability to the city and to those who use the land. So I commend the maker of this motion. I thought it was a good motion years ago, and, you know, because when you drive down 495 and you look to the right and you're probably going through Amesbury and you see what used to be a landfill and they're all sledding down, and I say, wow, why can't we do that in Lowell? So maybe at the time that I made it, it wasn't feasible. Maybe today it could be. I don't know. We're always trying to think of ways to make some money. So you're right on there, Councilor Elliott. That's what I say.
Okay. All in favor of the motion, say aye. Any opposed? The motion's adopted. Next motion by Councilor Milanazzo. The City Council requests the City Manager provide additional information relative to the extension of the contract between the City of Lowell and SMG. Seconded by Councilor Elliott. Councilor Milanazzo.
Thank you, Mr. Mayor. Through you to the City Manager. Last week there was a letter on our desk that you extended the contract with SMG for 2 more years. Again, I just want to know if it's 2 years from '06 or is it 2 years from '07, or I really don't know.
I believe, Counselor, it's expiring in June of this year, and it would be 2 years from this June. And that was before the Arena Commission, and they gathered up some feedback from those that had been using the facility, and then had a lengthy interview process with SMG.
Okay.
Under the terms of the contract, they would still have one other opportunity to extend it by either an additional year or an additional 2 years again. And what the Arena Commission is doing in the interim is they're continuing to get feedback from other tenants of the building who are using it, not on a permanent basis, but on, you know, sort of day-to-day events, and also compiling a list of goals for SMG in the future that they could try to.
Could we get a copy of that contract? Is that something?
The contract? Absolutely.
Yeah.
Yep.
Okay.
Yep.
The other thing is, 2 things actually. Saturday, as we all know, was a great day in Lowell. We had a great day of basketball at the Songus Arena, and SMG did a very good job. A lot of people in and out, and I think we really do need to salute the girls basketball team here in Lowell. They really did the city proud, and I certainly, as one council, want to congratulate the girls basketball team, and to the point of the motion, to SMG, because they did a good job moving a lot of people in and out on Saturday. Another point regarding the arena, it's come to my attention that we actually charge, and when I say we, the Arena Commission charges Lowell High School $10,000 for their graduation. To me, that's a large that's a big number. It's the same number that they charge any other high school, and I just don't, in my opinion, and I know we have to make money, I just don't think the high school should be paying what any other community would pay for that facility. So if that's something that we could check in.
I was not aware of that, Counselor. I will check that out.
Because again, if you look at Chuck Carney's report and they talk about, being a good neighbor, they provide free parking for high school graduation, for proms and so forth. I'm not saying provide it free, because I know they paid $3,500, I think it was, at the auditorium, but $10,000.
That's the first I've heard of that. I'll check it out.
Thank you.
Councilor Caulfield?
Thank you, Mr. Mayor. That's an excellent motion, Councilor. But I'm just wondering, was the MIAA sanctioning that tournament? Because if they were, they dictate the price of the ticket.
No,
So
I'm talking about I'm not talking about the price, I'm talking about high school graduation.
Oh, high school, I'm sorry.
Yeah, high school graduation.
I'm sorry.
Okay, all in favor of the motion, say aye. Any opposed? That motion is adopted. Next motion is by Councilor Ramirez. Request the City Council hold all of its subcommittee meetings in the City Council chamber in accordance with City Council Rule 5A. Second by Councilor Caulfield. If I could just read Council Rule 5A for those of you who might not be familiar with it. It says, subcommittee meetings of the City Council shall be held weekly on Thursday evening at 6:30 o'clock in the council chamber or as otherwise designated, except when a meeting date falls on a holiday, and during June, July, and August and September, when the meetings will be held on the second and fourth Thursday. Said meeting shall be televised and held on an as-need basis. So, Councilor Ramirez.
Thank you, Mr. Mayor. I appreciate you reading that. This is, the motion has actually two prongs. One, to enforce that rule, but number two, more to change the venue. This is actually an amendment of my January 3rd motion to have the mayor's reception room. I understand the manager spoke to us last week and told us that he is waiting for Jack Hall to get some information back from Comcast. And I know that Councilor Caulfield also had some concerns with the finances, and I'm not insensitive to cost and adding extra money to our budget when we have issues such as the summer programs to weigh in on. I'm also not insensitive to the historical and architectural integrity of the building. So if we can accomplish the initial spirit of the motion, which is to have all the subcommittee meetings televised here, I think that would go a long way. I think that some of these subcommittee meetings have turned into mini council meetings, and I know a lot of very important issues are debated and discussed in these subcommittee meetings, and I think the public has a right to know what goes on at them. This council has opened the door, so to speak, this year to a more open and accessible government, and it's just in keeping with that, Mr. Mayor. Thank you.
Thank you. Councilor Broderick.
Thank you, Mr. Mayor. I think it's a good motion, and I would support it, but I have a couple of questions that I think we maybe would need to address with someone from LTC, maybe, and in terms of also Thursday night meetings. We have 20-some-odd subcommittees now that we had 2 meetings last night, 2 tonight, and my concern would be that we're going to be limiting ourselves to one night to hold subcommittee meetings, or we're going to have a difficulty scheduling, and I don't know what LTC schedules, so if I don't know if by way of amending your motion could be maybe to have Mr. Haig come in from LTC and discuss the capabilities, what they can do for us, the availabilities, and maybe a report from Mr. Johnson as the availability of the room, because it may be something that we might not have the capability of televising, or we might not have enough time or time available to have all the subcommittees in this room. And maybe we can do something in the interim, but I'm concerned because just in the last 2 days we've had 4, and to have them only on Thursday night at 6:30, I think may pose a difficulty.
On that point, if I could, the rule does say or is otherwise designated, so I don't think you're stuck to Thursday, even under the existing rule. So it's really the issue of the television.
And then we fall back again on the availability.
Right.
Monday
I mean,
night
that is
we
an
moved
issue.
CBA and Planning Board in here. Wednesday night is School Committee to 2 Wednesdays a month, I believe. Tuesday night, we're here. We're leaving Thursday and Friday and every other Wednesday, really.
Okay, Councilor Caulfield?
Thank you. First of all, I want to applaud Councilor Ramirez for bringing in an alternative plan, reducing the cost of installing cameras and microphones and so forth in the mayor's reception room. I applaud you for that. We have the facility right here in this room, and I believe the ZBA meets on, what, every other Monday? And the planning board meets every other Wednesday.
No, Mondays.
Or Monday? Monday.
Monday now.
I still think there's ample time to have subcommittee meetings prior to the council meeting. You have Wednesdays available and Thursdays. I think if we work at it, we can make it work. We can. And I don't know what the exact cost is, Mr. Manager, but the twofold. First of all, the cost, and second of all, interfering with that beautiful room that Council Islandiana, who we modeled years ago. But it's, I think if we work at it, we don't have to televise every little single subcommittee meeting. I think the major subcommittee meetings, neighborhood traffic, economic development, whatever. I think it's in Parks and Recreation. But what I'm saying is we can make it work if we want to make it work. And we can find the time to make it work.
Councilor Donahue, then Councilor Mercier.
Thank you. My recollection when this motion rule change went in was almost, I think, 9 or 10 years ago. The idea was to have a set time because LTC wanted to be able to schedule someone, and they weren't constantly getting called at the last minute. And then councilors found that you'd have to wait so many weeks to schedule on that Thursday time slot, so people just stopped doing it and scheduled them when they wanted. And then after a while, nobody was going on Thursday night, and LTC was, having someone standing by to do it. So it does require some input from LTC. I think it's a good idea. And Thursday was picked for just the reason that was cited. Monday night, the council chamber was being used. Tuesday, Wednesday, and Thursday was really the night that was free and clear. So maybe if we can get some input from LTC, if we could have a standing time slot, on either before council meetings, as Councilor Caulfield said, Thursday night as an alternative. And I guess the council will have to decide, do they want to make it mandatory or rather up to the discretion of the subcommittee? Some things require a quick vote, just because, let's say DPD needs a vote on something that's going to be coming to the council. So maybe that doesn't require the time and expense of putting it on TV, but other things of more substantive nature. So I certainly support the motion, and maybe the first step, as has been indicated, that we get some report from LTC of how we could make this work.
Thank you. Councilor Mercier?
Yeah, thank you, Mr. Mayor. First of all, I think it's a great motion. I think that the role of the subcommittees in the last few years has increased to the point where they're like city council meetings. And that if that's going to be the case, as it has been, and this is good for the city, then they should be televised. The people at home should be made aware that when they get a report to the full city council, it's a sanitized report because it needs to be. And when you think of just last night's meeting, which I was unable to attend, how much of a report can you give about a meeting that took a couple of hours? And so I think it's important that transparency of the subcommittees is as great as the city council itself. So I think that that's a good motion. I think that the city council chambers is under the purview of the city council, and that we should have first priority of these chambers as it relates to what we're trying to do. Second of all, I would hope that the manager would still continue pursuing what it would cost for wiring the mayor's reception room. Just what the cost is, and let's find out, if it is prohibitive, because I think that at some point in time, that should be done as long as it doesn't affect the architectural beauty of the interior of that room. But basically, I think the next subcommittee meetings should be in the council chambers and should be televised. And I think that the manager who controls what LTC does can make sure that it is televised, because it's very important now because of the involvement of the subcommittees in the operation of the city, that they are like mini council meetings. And I think that the general public should be made aware of what takes place, because many times the details of what takes place at the council meeting really took place at the subcommittee meetings, and therefore I think the general public should be made aware of that's happening and the opportunity to view it. So I think it's a great motion, and I think it should be put in place as soon as possible.
Thank you. Councilor Elliott.
I agree with Councilor Armin Mercier. In fact, we in the technology subcommittee meeting this evening, Mr. Fernandez, the director of MIS, indicated that sometime in the future, people might be able to, albeit on a rebroadcast, be able to, we can transmit, record and transmit so people can look at it on the computer. So it's sort of just the next step where, and it may not be live, but we will still need cameras to at least record, those subcommittee meetings. So while it makes some sense to use this chamber as much as we can, last night there were 3 meetings here. We ended up, actually, the subcommittee moved into the manager's conference room to have that 2-hour meeting. So the building is getting used. So I think we still need to look at long-term, putting cameras, remote cameras. I mean, I don't think these cameras that are in this chamber, they're not that invasive. I don't think they spoil the architecture of this room, and I can only envision that it'd be something similar in that room. So I agree with, I think that we should continue and look to see what that cost is. It can't be that significant. We're going to use it in the future. And that room is used for how many press conferences? Winterfest, Folk Festival. People should be able to see that live too. Thank you.
Okay. Councilor Donahue?
Thank you. You learn something every day. The technology subcommittee, as Councilor Elliott said, that's called a podcast. And podcast, who knew? And so that's something that MIS said that they could start doing, not next week, but pretty soon. And people can go online and watch city council meetings, or upload or download or sideload. I don't know what they do with them.
Okay, Councilor Armin Mercier.
Just a final note, if it becomes prohibitive or becomes too complex, then we ought to, curtail some of our subcommittee meetings.
Okay, all those in favor of the motion, say aye. Any opposed? The motion is adopted. The last motion is mine. Any objection to read it from here? No? Okay. City Council requests the city manager have National Grid Company remove the light pole stump in front of 176 Walker Street. Second by Councilor Rita Mercier. The motion speaks for itself, Mr. Manager.
I think it's done, Mayor.
It's done? Okay.
Yeah.
All those in favor, well, then it's withdrawn. We don't have to vote it. Councilor Milanazzo.
Just suspend the rules for one quick second, if we could. It's having to do with something was left on our desk regarding the Greek Independence Day.
All right. Motion to suspend the rules by Councilor Milanazzo, second by Councilor Armin Mercier. All those in favor say aye. Any opposed? Councilor Milanazzo.
Thank you. This past Sunday, a number of us participated in the beginning of Irish Cultural Week, and we actually had a procession from St. Patrick's Church over to City Hall, and then we went back to the Irish Monument at Cardinal O'Connell. And unfortunately, Mr. Manager, the trash in the street was just deplorable. So I just would like to make sure that on March 26th, when we have the Greek Independence Day, that the area between here and the Greek Church would be cleaned up, if that can be done. March 26th. But unfortunately, this past Sunday, again, it just
What was the
not
problem?
blaming anybody. I'm sorry. It was trash. Trash. And I know we're just coming off of winter, but the trash was just pretty tough. So March 26th is the date.
Okay. Okay. Motion. Councilor Caulfield.
I just want to touch on Councilor Milanazzo's request about the trash. The canal that we walked over, totally disgraceful. Absolutely, totally disgraceful. I would be ashamed for anyone to come in here and from outside the city and walk over that canal. Well, that was awful. Name it, it was in there. Bikes, shopping carts. It was awful. Awful.
Thank you, Mr. Mayor.
Councilor Rita Mercier.
Since we're in the mood to extend this council meeting a little bit longer, I'd just like to ask through you to the city manager if we could have some sort of a list of the line crosswalk paintings. I know that it was a beautiful day last week, and I saw the street sweeper out, so I know spring is in the air and the crosswalks will be down soon. How are we going about that? Is it going to, by section of the city, could we have a report on that? Thank you.
Okay, motion to adjourn by Councilor Armin Murcia, seconded by Councilor Milonazo. All those in favor say aye. Any opposed? The meeting's adjourned.
Public safety?
Sidewalks.